David Rudolph, and I represent the appellant in this matter. I want to start by just saying that the record in this case establishes that James Blackman was actually innocent of this crime. 3 judges of the Superior Court in North Carolina found that fact, that he was actually innocent by clear and convincing evidence, the highest civil standard that exists. That's important because it means that we know that the incriminating admissions that he made on October 26th of 1983.
I'm going to ask you to put that microphone as close as...
I'm sorry, is that better?
That's much better, and you don't be afraid to speak up.
People have not accused me of that before, so I'll do my best. In any event, what it shows is that although he made those admissions on October 26th of 1983, those admissions were absolutely false. You can't have someone who is actually innocent, wasn't there, making admissions that are true. And what we also know is that those admissions recited and were consistent with the physical facts in the case. And so that leads us to the question, how is that possible? How is someone who is not there able to make admissions to physical facts that are accurate? How does someone who knows nothing accurately describe the crime? Our complaint alleges that that happened because the defendants in this case, Mr. Holder and Mr. Mundy, studied James Blackman's mental illness, literally studied it. That's in the complaint. And they either intentionally, recklessly, or both used that information, used his psychiatric problems, his delusions, his hallucinations, his schizophrenia, to feed him facts, to convince him, in essence, that although the good James Blackman, who was sitting in the room with them, may not have known anything about the case, the bad James Blackman, who they asked him to imagine over at the dorm room, he knew these facts. The good James Blackman, he didn't have a dashiki. He didn't have it.
Can I ask you what my biggest concern about this aspect of your claim is? Let's posit that all of that is true and that all of that is troubling. That sounds to me like a self-incrimination clause claim, not a due process claim. I mean, I was tricked into confessing either because they fed me false information or because they took advantage of my mental illness or because they threatened me implicitly or explicitly. I mean, that may well be a good constitutional claim, but it strikes me as a self-incrimination claim, not a due process claim. And Graham versus Connor and other cases say that when there's a constitutional provision that is sort of gets at this thing, we use that provision, not due process. So I understand, and I want to get to it in a minute. I know you have other claims other than they fed me false information and made me confess, and I want to talk about those. But why isn't they made me confess to something I didn't do properly thought of as a self-incrimination claim, not a due process claim?
Well, I don't think our claim is really that they made me confess. They enabled it. They fed him the facts that caused him to adopt
Well, not they made me confess, but my confession wasn't voluntary because it wasn't the choice of an independent and free will. That sounds like a self-incrimination claim to me.
Well, and that's fair, and indeed...
But you don't allege coercion either.
Well, actually, there are some places in the complaint where we do allege coercion, but the title of it...
It seemed to be hard to do because the North Carolina Court of Appeals heard that claim and said it was not accurate.
Well, actually, when we read the opinion, first of all, that was a factual opinion. In other words, there was conflicting evidence before the trial judge as to whether Mr. Blackman was competent or not competent. The trial judge in that matter found that the evidence that he was competent was more persuasive. The Court of Appeals was bound by that finding. So, and indeed, they even said...
Didn't they find that there was no coercion?
Well,
and that's specifically found in their opinion?
I think what they found was that it was not involuntary. I think that's the term they use. But, in terms of that particular opinion, it doesn't really matter at this stage because...
My only purpose in asking you that was that, there can be a line sometime between coercion and some sort of manipulated trickery sort of a thing.
Yes, sir.
But it just seems like to me, if you're going to go down on the side of the line that says coercion, you have a very, very difficult claim to make.
Well, and I'm not sure I agree with Your Honor, because in the Washington case, this court made absolutely clear that the fact that someone has been exonerated, that the case has been settled in the state court, means that Rooker-Feldman just doesn't apply.
But the law draws a distinction between manipulative tactics and coercive tactics. You have a good guy, bad guy, cop or whatever, and you have people pretending to be empathetic with a suspect when in fact they're not. And those sorts of manipulative, for want of a better word, manipulative behavior is thought to be legally distinct from something that is coerced.
Well, I think there's a spectrum there, Your Honor. And what we're saying is that what happened in this case, where you take someone who is schizophrenic, who has delusions, who has hallucinations, and you feed those, and you take advantage of those consciously and intentionally because they studied them. And now they're taking advantage of those, and they're saying, well, imagine you're over here, and imagine you're on the dorm floor, and imagine this girl is screaming. What do you do next? And he's got all these delusions and hallucinations. Our position is that that shocks the conscience. And so to address Your Honor's question, this goes far beyond, I think, a self-incrimination issue. It goes far beyond a Miranda issue.
Well, I guess, Mr. Realtor, I have one last question on this, and then I want to turn to the other thing. But, can you cite for me a case where a court has said that the suspect himself said the following words? He said the following words because of something the police did. So we're talking about a statement by the suspect.
Yes, sir.
That the statement was allegedly produced by what the police did, and we treated that as a due process claim, not a self-incrimination claim?
Yes, sir. Well, I'm not sure this court has dealt with that, but I can give you 3 other cases that have dealt with that. Halsey versus Pfeiffer, which is a Third Circuit case discussed in our brief. Weary versus Foster, which is a Fifth Circuit case discussed in our brief. And Riccuti versus New York City Transit Authority, which is discussed in our brief. That's a Second Circuit case.
So okay.
I was just going to say, in each of those cases, the police, in essence, either wrote out a statement and had the person sign it. They questioned him and wrote it out, and the person just signed his name. Mm-hmm. Or the person made those statements themselves, and the court said, no. You can't feed somebody information and then say it's his own words.
So let me go to something that builds off with what you just said, because I think it's a difference.
Can I ask a follow-up question before you get there, if you don't mind? But can you give us a case from 1983 or before from the North Carolina Supreme Court, this court, or the U.S. Supreme Court that encompasses in the qualified immunity context your claim as you answered Judge Hyten's question?
Yes, sir. Well, I mean, the cases that this court has followed in terms of when a right is clearly established is that we're talking about the contours of the right. It doesn't have to be a case on point or even a case with similar facts. We're talking about, would a reasonable police officer be on notice that what he or she was doing was violative of the person's rights? And I think in this case in particular, when police officers study somebody's mental illness, know that he's schizophrenic and delusional and hallucinogenic, and they then prey on that. And
is there a case with that scenario from 1983 or before from any of the relevant jurisdictions?
Not that I'm aware of as I sit here right now.
So then, okay, can I ask you something that builds off the first one you said?
Yes, sir.
It strikes me that there's a very big difference between two things. One is the police tricked someone into saying something, but he definitely said it, and my inclination continues to be that's a self-incrimination clause claim. The other possibility is that he did not in fact say something, and the police falsely claimed that he did, right? The defendant never actually uttered these words, but the police are attributing to him words he did not say. That to me doesn't sound like a self-incrimination claim, and that starts to sound like manufacturing evidence to me. Am I right that you allege they did that at least once here, that they attributed to Mr. Blackman statements he did not in fact say? Specifically, I'm thinking of pages 50, JA 51 and 54, where you say that they represented that he said X, but when you look at the transcript, he did not actually say X?
Exactly.
Okay.
That's exactly right. And indeed, we don't know what he said when they were at the college because they took no notes. They didn't tape record it. So they brought him to the room where this all happened. When he couldn't describe it, they take him to the room. They take him to the scene of the attack. And you know, at that point,
Well, what's wrong with taking him to the scene of the attack and having him identify the place where the attack took place?
because he's already said he doesn't know that. He can't describe it, and he's schizophrenic.
Well, I know, but there are going to be a lot of defendants who are going to claim that they had some kind of mental health problem or disability, and that the police took advantage of that.
Well,
And where do we draw the line?
to answer your question, I think we draw the line when there are psychiatric records going back years that establish that he's schizophrenic, he's delusional, he hallucinates, and the police know that. That's a big distinction in our case from some of these other cases, because as I recall in Washington versus Wilmore, part of that opinion was these officers didn't know.
But it seemed to me that part of your real beef was that the prosecution had a thin case, and that it should not have been brought. And you go on about the absence of the shaky nature of the ID,
Yes, sir.
and you talk about the absence of a fingerprint match, and it seems to me that you talk about the delusional quality of the defendant, but it seemed to me, reading these briefs, that you say, this is a thin case. It should not have been brought. And, okay, I understand that, but if that's your problem, aren't the prosecutors the ones who are at fault here? Because they make the final call, and the police or investigators will often say to a prosecutor, here's what we've got. But the police don't make the final call on whether to let the prosecution go forward. That's the prosecution's call. You can't sue the prosecutor that easily because they have absolute immunity rather than qualified immunity. So as a result, this is shoehorned into a coerced confession case, which has the difficulties that we've been exploring, and the distinction that Judge Heitens is drawing between a confession that is obtained by trickery and manipulation and a false confession that is coerced. But the problem is, I think you rerouted the case into this coerced confession mold when your real beef was with the overall thinness of the prosecution, which is a prosecutorial matter. I don't blame you for being frustrated with the fact that prosecutors have absolute immunity, but there's nothing we can do about that. And so it seemed to me that this was you were rerouting and trying to make it fit into a coerced confession claim when your real beef was with the exercise of prosecutorial discretion.
My time is up, but may I answer?
Yeah, sure.
Thank you, Your Honor. The problem is the prosecutors didn't know everything. There's no evidence in the record. There's nothing to support that the prosecutors knew anything about how this statement was obtained. They relied.
How do we know that?
There's nothing in the record either way about that. And so
Suppose the police officers were candid with the prosecutor and say, here's what we've got, and describe the problems that you've alluded to.
Here's why I think that didn't happen, Your Honor. Because when they got an eyewitness into their office, into Central Prison, and she said, that's not the person. And they said, well, he's confessed. And she said, well, if he's confessed, he's crazy, because he's not the person. And they suppressed that. They never wrote that report up. They never informed the prosecutor of that. So that tells us.
Do we really know what conversations took place between the police and the prosecutors in this case?
We know that they didn't write a report, they didn't tape record it, they violated their own regulations by not making a record of that identification or lack of identification. That seems to me to be an intentional act. And at least at this point, we're just at a motion to dismiss here. We haven't had any chance to do any discovery at all. So what we're really asking this court to do is to send it back so we can flesh out some of these issues.
Flesh out what? The conversations between the police and the prosecutor?
Among other things, yes, sir. That's the whole purpose of discovery. Anyway, that's what we're asking. We're asking the court to send it back so we can do our discovery. This is a very premature motion.
Well, yeah, I understand that, but, the qualified immunity or any kind of immunity is an immunity from suit. I understand. And the deeper you go into the case, the more the value of the immunity is depleted.
I agree with that. But you have to balance that against whether or not any facts can be developed to show that there shouldn't be any immunity. I mean, it's a balancing, it seems to me, Your Honor.
All right, let me ask my co-panelists if they have questions.
One more question. If you could go back to your answer to Judge Hyten's last question and point us again, where exactly in the complaint do you allege that the police officers fabricated a statement by Mr. Blackman that he did not make?
I'll see if I can find that quickly, Your Honor. And if I can't,
Well, just tell us when you get up on rebuttal. You can
Exactly. Thank you, Your Honor. Thank you very much.
Thank you. Mr. Benton?
Good morning, Your Honors, and may it please the court. Again, my name is Jason Benton. I represent one of the individual capacity defendants in this matter, James Holder, a former Raleigh police detective. Rachel Keene represents the other individual capacity defendant, Andrew Monday, but I'll be arguing on behalf of both officers here as their positions align. Your Honors, this is not a fabrication of evidence claim. Rather, it's a doomed, coerced confession claim that is subject to qualified immunity. In 1983, there was simply no controlling legal precedent putting a reasonable law enforcement officer on notice that asking a mentally infirm suspect leading questions was unconstitutional. If it were otherwise, appellant would have presented that case to Your Honors. The North Carolina Court of Appeals in 1989 would have presented that case, or we would have seen it in this circuit or in a district sitting in this circuit. The lack, Your Honors, of any legal precedent to support a coerced confession has led this appellant to avoid that characterization of his.
Well, what was the clearly established law at that time in your view?
In 1983, Your Honor, what we understood to be clearly established was that police coercion included things like depriving a suspect of food, water, sleep, physical abuse, psychological abuse, making promises in exchange for a confession, all things that did not exist here. There was no clearly established law preventing or putting an officer on notice that asking leading questions.
So what you're saying here is the allegation is that the police were preying on someone's mental infirmity, or taking advantage of someone's mental infirmity. And you're saying, that's what they're saying, and you're saying that's not enough to abrogate qualified immunity.
That's correct, Your Honor. That's correct.
And but you know, you get maybe a hard case makes bad law. He seemed pretty pretty far gone. The alleged perpetrator here, I guess the strongest point you make is that if we take the whole doctrine of coercion and move it into the realm of manipulative activity and activity where interrogation takes advantage of someone's susceptibility or someone's claimed disability, that it's hard to draw the line. You've got a difficult case on the facts here, but you have a stronger point with respect to the slippery slope argument and how far we would go if we head from the classic definition of coercion into some other definition of a Fifth Amendment violation.
Right, Your Honor. And even if this court, we would contend, Your Honor, that these facts that are alleged do not constitute coercion. But even if this panel believed they did, the further point is there was no legal precedent in 1983 to let officers know that this conduct was regarded as coercive.
Can I just ask one thing on the coercion? Because you sort of mention it, but you don't. Am I correct that you are not arguing that the North Carolina Court of Appeals rejection of the self-incrimination claim has any sort of claim preclusive, issue preclusive, or Rooker-Feldman? I mean, your brief prominently notes that they rejected this claim, but your brief never argues that it's preclusive or it's binding or can't be collaterally. Am I right about that?
You are, Your Honor. It's simply a matter of trying to prove a negative. That if the appellate court sitting in 1989 didn't find it, if the appellant hasn't presented it, if the Washington line of cases didn't find it, it's just not there. And the reason why we see a fabrication label here is because the appellant contends, and we agree as appellees, that any reasonable officer in 1983, in the year 1983, and long before that, frankly, would understand that fabricating false evidence against a suspect violates due process. And so what this is, Your Honors, is an attempt to costume that coerced confession claim that would fail into a fabrication claim. It's an attempt to fix a very real, clearly established problem.
So given that, can I ask you about the two places that I think the complaint at least arguably does allege fabrication of evidence, and ask you for your thoughts on those? So the first one is on JA 54. This is where, I'll just read it while you find it. It says, Blackman requested earlier that he wanted to show the investigators that he went to Latham Hall and also shows them what he did and where it happened. The transcript of the interrogation does not include any such statement by Blackman. I mean, maybe that can be read different ways, but we are on 12b6 and we have to construe the complaint in the light most favorable to the plaintiff. Why is that allegation not potentially read as saying the officers attributed to him words he did not say?
Well, Your Honor, it's possible, I guess it could be construed that way.
And if so, well, that's fabricating evidence, right? Attributing words to a suspect that the suspect never uttered is fabricating evidence, isn't it?
It can be, Your Honor. Let me answer it this way. Number one, there's likely a causation problem for them on that allegation.
Totally agree, there might be a causation problem.
Right? and number two, Your Honor, by appellant's own brief and their own legal authority, the litmus test for determining whether there is a fabrication of evidence is whether the defendants know that the evidence is false. And here, where you're talking about a suspect actually answering questions, albeit to leading questions, and you have an allegation.
Wait, but if you attribute, if I had a conversation with you, and then after that conversation, I told a third party that you had said something that you did not in fact tell me, I would know that you did not in fact say that, right? Or at least it's plausible I would know that you didn't say that.
That's fair, Your Honor. That's fair. And I can't quibble with that point. I guess I'd go back to, Your Honor, the very real and present question of, is there causation?
No, sure. And so look, I appreciate that. Let me ask you about the other one. Because I agree, most of the complaint to me sounds like a coerced confession claim or an involved. So the other one is on JA 62 to 63. This is the part where during the lineup, the witness is told that Mr. Blackman has confessed to the murder after she failed to pick him out of the lineup. Had he in fact confessed at that point?
According to the complaint, he had.
Okay.
Your Honor, the detail concerning the confession is on October 25, 1983, and October 26, 1983, some of which were interviews, some of which were, I guess, what we could call field trips to the location.
But how isn't it tampering with a witness to tell the witness, like, so the whole premise is I bring you in and I say, is this the guy? And the person says, no, I don't think it is. And then I said, would you like to reconsider your answer in light of the information I'm about to give you? Isn't that pretty classic witness tampering?
Well, Your Honor, that could be regarded, as we sit here today, inappropriate policing, but it doesn't necessarily rise to the level of a federal constitutional.
You think a reasonable police officer in 1983 could have thought it's okay to tell a witness who just said, that's not the guy, would you like to think again, because that guy totally said he did it? Like, doesn't that defeat the entire purpose of a lineup?
Your Honor, I understand Your Honor's point there. I will say this, that as we deal with the facts of this case, that would have come after the confession. The train has left the station at this point. You have officers here that have interviewed Mr. Blackman. He has confessed before that physical lineup.
But that's not true, because the defendant confesses, and then at trial, the defendant tries to argue his confession wasn't true, it was false. I realize this was an Alford plea, but imagine this case goes to trial, right? Which could impact whether someone takes an Alford plea. So the defendant has made incriminating statements, and at trial his strategy is going to be those were false. They were, even if they weren't coerced under the Fifth Amendment, I was tricked, I was manipulated, I said things that weren't true. It's really helpful if the prosecutor can say, well, we know he's lying now because a witness totally said it was him. So I don't think you can say the train has necessarily left the station, because the prosecutors can then say, good luck trying to walk that confession back now that a witness has said it's you.
Right, but in terms of measuring the conduct of the officers in 1983, if they're faced with evidence, and this is in the record, in the complaint, of inculpatory and exculpatory evidence before there's a confession, and then there's a confession, inculpatory statements on top of that, that's what I mean when the train has already left the station. And if we're measuring the conduct of these officers in hindsight, that's where I think we would have a problem.
When you look at the gravamen of the complaint, take the complaint as a whole, and take the argument as a whole. I think the argument here is that the officers here preyed upon the suspect's weakness. It is not that they put words in the suspect's mouth. Now, I suppose it is a spectrum, and that at a certain point, preying upon the weakness could be putting words in the suspect's mouth. But basically, it seems to me the gist of it is that they preyed upon a known weakness. And not that they put words in their mouth or falsified something or did this or that. And the question then becomes, was there a law that put the officers on notice that interrogation which preyed upon a suspect's known weaknesses, somehow a constitutional violation? But I do think that the claim has not struck me of something which is fabricated or falsified or deliberately falsified. The claim is you knew this person had a weakness and a mental disability, and you preyed upon it. Now, that may be wrong today, and it may be wrong as a general moral matter. It may be wrong. But the question is not as a matter of moral abstraction, but what the law was at the time that the officers were undertaking the investigation. And whatever we might think of this as a moral matter, as a legal matter, the question is whether the police officers were put on notice that this was in violation of the law. And I understand, maybe I'm missing something, but that's what I understood to be the gravamen of your argument.
That's right, Your Honor. In fact, there is no case law that we've been able to uncover, nor I would submit, Your Honor, that the appellant has that would have put the officers on notice of just that point. In fact, although it's a district court decision in Washington too, that court looked at 1983 conduct, the conduct in 1983 of officers interrogating Mr. Washington, the suspect in that case. Mr. Washington was mentally infirm by his own allegation, and that court said there was nothing to put these officers on notice, that asking him leading questions was constitutionally improper. In fact, it went further to say even if they knew he was mentally infirm, there was nothing to put them on notice in 1983 that act of asking that suspect questions was unconstitutional.
No, I'm just, the whole question, did you have a question?
No, go ahead.
The whole question of whether they knew someone was innocent or suspected someone was innocent, does that play into that? Play into this at all?
It does in this case for this reason, Your Honor. Here we have admittedly no acts of coercion, at least no acts of coercion that were recognized as such in 1983, and we have an admission from the appellant that these officers believed that Mr. Blackman committed the murder.
Didn't the district court give way too much weight to that fact? You can absolutely frame someone you think is guilty, right?
Yes.
Right, and it is absolutely unconstitutional to frame someone even if you really believe they did it.
Agreed.
Okay, so why does that matter? I just noticed that the district court attached an enormous amount of significance to that, and I guess with respect, my reaction is, I don't know why that matters, because I can absolutely imagine scenarios where police officers honestly believe, you could hook them up to a lie detector test, they believe this person did it, and they believe he's gonna walk, because they believe they can't get evidence to prove that he did it, and they make up evidence. I'm not saying that's what happened here, but I could totally imagine that situation, and that is absolutely unconstitutional, no matter whether you believe he's guilty or not, right?
Well, Your Honor, and appellees don't dispute that. We don't argue that. We agree with Your Honor's assessment. I think
But what they subjectively, to follow on Judge Hyden's question, what they subjectively believed, how is that important in a qualified immunity analysis? Because the qualified immunity analysis doesn't turn on a subjective belief. It turns on objective reasonableness. Sure. And objective reasonableness is what the law lays down.
Right. Would a reasonable officer in 1983 who believed that Mr. Blackman had committed the murder and did not perform any coercive acts, would those officers believe they had committed a violation of the Constitution? I think that's how it fits in, and the answer to that is no.
But I think what Judge Wilkinson was just saying, I think under Harlow, the first sentence of that should be stricken, because under Harlow, I don't care what they believed. Because, I mean, this is what's good for the goose is good for the gander, right? So we say that a plaintiff can't get past qualified immunity by saying that in their heart they meant bad things, right? Harlow, you cannot get past qualified immunity by saying, I know a reasonable officer wouldn't know it, but this officer had malice and hate in his heart. And Harlow says that is irrelevant. You can't get past qualified immunity. But the flip side then is also true, which is that by saying, I swear to God that I meant no harm, isn't also a defense in a qualified immunity situation.
Understood, Your Honor. And I would just say this, if you accept the appellant's own contention that the litmus test for fabrication of evidence is whether the defendant knew that the evidence itself was false in order for there to be fabrication, then the real problem becomes when you're talking about the fabrication being what the suspect actually said in response to questions.
No, I'm totally with you on that.
Okay.
I'm asking you, but about, again, you've heard me what I've said about about page 54. Page 54 strikes me as different. If they said he said something he didn't say, why could a reasonable officer in 1983 have believed that was constitutional?
Right, and I understand Your Honor's point there, and again...
and can I have a follow-up on that then? Because we don't, like, this is a multi-count complaint, right? So count two, to me, count two just looks like a coerced confession claim. That just looks like a straight-up coerced confession claim. But count one is broader than that, and so I guess my biggest concern about the district court's opinion is that it starts with the premise that at heart this seems like a coerced confession claim. That fails. But what I don't see the district court is going through count by count of the complaint and asking, okay, assuming that you can't bring a coerced confession claim, that probably requires dismissal of count two. It maybe requires dismissal of a bunch of the allegations in count one, but we do complaints count by count, right? We don't say what the plaintiff is really complaining about here is X, and X is invalid, so we dismiss the whole complaint. That's not how we do 12b6, is it?
No, Your Honor, but I think that all of the federal constitutional claims all culminate in this allegation that these officers somehow fabricated.
But that's not true. There's a malicious prosecution claim. There's a manufacturing evidence claim.
Right, but the malicious prosecution claim by the allegations listed in it all derive from the allegation that these officers fabricated, coerced, whatever label you want to put on it, the confession. That's what the malicious prosecution claim relies on and derives from. And Your Honors, I would say this, there are only really two Fourth Circuit decisions that the appellant relies on to try to contend that this is, in fact, a fabrication of evidence claim. And neither one of them fit the facts here. The first one is Washington versus Wilmore, which came before this court. It was the appeal of Washington 2. And the problem, though, for the appellant is in that case, the court was only considering and addressing Officer Wilmore's claim. That is, the claim against Officer Wilmore that he fabricated evidence by mischaracterizing the confession in a police report, not what we have here. The other Fourth Circuit decision is Gilliam versus Seeley. But that case, Your Honor, involved signed written confessions in the context in which the suspects did not understand they were signing confessions. It also involved clear acts of police coercion. In other words, in that case, officers were yelling in the suspect's face. Officers were making threats, including the threat of death by gas chamber if the suspects did not confess. It also involved racial epithets, something that just doesn't exist here. There are also out-of-circuit cases they rely on, Your Honor, many of which regard police conduct that occurred after 1983. One case they doubled down on is the Gonzalez case, which is a district court case from Illinois. But again, not only did that case involve 1994, not 1983 conduct, but there was typed out confession by Gonzalez there, and he signed it without being able to read it or understand it, and there was clear officer coercion. The officers told the suspect that a judge would let him go in spite of any confession if they confessed. He was deprived of food, water, and sleep, and the interrogation. Your Honors, I see that my time is up. May I briefly conclude?
Yeah, I was going to say that the police belief in someone's innocence or not, it does factor in at the very beginning of a prosecution, or I mean, the very beginning of a case, at the very beginning of an investigation. If the police believe someone is innocent, they're going to drop the investigation. It's not going to go anything. It's not going to go any further. The question is, when something has progressed this far, you know, we're not at the situation where the police are saying, after talking to someone, saying, well, we're convinced he's not a suspect. They may drop the whole thing. And so police, in view of innocence, it seems to me, is relevant at a certain stage. At a certain point in the investigation, when it's gone as far as it has, it seems to me that the subjective belief in innocence is not a police call, is less and less of a police call the further the case goes along. And at a certain point, it doesn't seem to me legally relevant what they believe, that that's the prosecutor's call and maybe eventually the jury's call if the prosecutor, as here, went forward. But what the police believed seems to me more important at the very beginning of the process and the very beginning of the investigation than it is with something that went as far as this one and dealt with how you assess and size up numerous items of evidence. See what I'm saying?
I do, Your Honor, and understood. And Your Honors, ultimately, what we'd ask is that you affirm the district court's grant of dismissal as to the federal constitutional claim and affirm the denial of the motion to modify and or amend of the appellant. Thank you, Your Honors.
All right, counsel, you have some time for rebuttal.
I just want to address quickly Your Honor's point about whether words were put into Mr. Blackman's mouth. And the answer is yes, they were.
Can you again put the...
I'm sorry. You asked whether words were put into Mr. Blackman's mouth. And the answer is yes, they were. They were put into the mouth of the bad James Blackman. So, for example, when the good James Blackman says, I never owned a dashiki, I never owned a knife, they then go to the bad James Blackman and say, what about that bad James Blackman? Was he wearing a dashiki when he raped this woman? Oh, yeah, that's right. And the knife, did he have that knife? Did you see this knife? Oh, yeah. So they are putting words in the bad James Blackman's mouth. That's the hallucinogenic James Blackman. So it is very much a fabrication case in that sense. They fed him the facts. And that's why I think it takes it out of the coercion issue. They fed him the facts. When you feed somebody the facts and they adopt those facts, that is fabrication. That's the essence of fabrication. Your Honor, to answer your question, I think Judge Heitens has answered your question about where in the complaint it alleges.
Right. Tell us what that paragraph 191, what cause of action specifically does that relate to? Page 54.
Thank you, Your Honor. My eyesight used to be better. What it relates to is that it relates to the fabrication and what they're claiming he said, because if he said, oh, I want to go over to Latham Hall, if I go over there, I can explain it to you. If he actually said that, then that would be some reason, as Your Honor pointed out, to take him there. But what he said was, I don't know anything about Latham Hall. I've never been to St. Augustine.
What part did Miranda warnings play in all of this?
They never gave him any Miranda warnings because he wasn't in custody. He came and went freely. They bought him Cokes. They took him to McDonald's. They drove him around the city. They made friends with him.
Did they give him Miranda warnings at any point?
No, sir.
Could you bring a claim on the absence of Miranda warnings?
I don't think so, because it was pretty clear that he was free to go, that he was never under arrest or restrained in any way. So
Does that weaken your coercion claim?
I'm sorry, what's that?
If he's free to go at any time, does that weaken the coercion claim that you don't have a claim that the interrogation was even custodial?
No, because it's not about the physical way in which the interrogation was conducted. It's about the mental way. It's the psychological way. And you asked earlier about a case that established in 1983 that psychological coercion was violative of the Due Process Clause. Yes, Gilliam versus Seeley, which this court decided in 2019, found that a plaintiff who was coerced by psychological means, stated a due process claim. And also that that claim
What year was
existed.
that?
I'm sorry?
What year was that?
That was 2019.
We were looking for 1983.
No. They said it existed in 1983. That case arose in 1983 or before 1983.
All right.
So the case in the court in Gilliam said, and that claim existed in 1983.
Let's go back to that paragraph 191.
Yes, sir.
Because as alleged in the complaint, it says the transcript of the interrogation doesn't contain any statement by Blackman that he wanted to show investigators. But there isn't a follow-up sentence that I would have expected to see that says on information and belief, he didn't say that. So I'm not sure how that helps you, because it seems like to me you have a threshold Twombly problem here. All you've alleged is there's a transcript that, as a matter of fact, doesn't have a particular statement in it. You haven't alleged that there's a fabrication of anything.
Well,
Have you?
my time's up. May I answer your question?
Yes, you may.
Thank you. It's not a Twombly question because at this stage, we're entitled to the reasonable inferences drawn in our favor.
So why is it reasonable that statement of fact, that this particular sentence doesn't appear in the transcript, why is it reasonable to deduce from that that there's something fabricated elsewhere?
Because they transcribed the entire interview. The whole interview was transcribed. There was nothing that was not transcribed other than this trip to Latham Hall.
And doesn't paragraph 191 not just say they're not in the transcript, but that they are in, doesn't the second sentence say they are inconsistent with the statements? The second
Yes,
sentence of paragraph
exactly. I'm out of time. Thank you, Your Honors, very much.
All right, we thank you. Clark, whenever you're ready.
Thank you, Your Honor. Good morning. My name is Denise Clark. May it please the court. I represent appellant Dawn Polk. On behalf of Ms. Polk, I'm requesting that the court reverse the district court's conclusion that Ms. Polk's discrimination claim was preempted by the Railway Labor Act, which I'll refer to as the RLA. After the parties fully briefed this case, the Fourth Circuit issued its opinion in Giles versus National Railroad Passenger Corporation, which I believe is known as Amtrak. That's at 59 Fed 4th, 696, and that's a 2023 case. The court was very clear that this was the first case in which the circuit took the time to review the RLA's preemptive reach. Generally, it has been found by courts in this country that the RLA does not bar a plaintiff from bringing a claim under an independent federal statute, and this court concluded that, in fact, that is the case. In Giles, there are a couple of distinctions. First, Ms. Polk was at a motion to dismiss phase. In Giles, it was a motion for summary judgment, and I believe that there had been a record that was completed in Giles.
As a preliminary matter, based on the supplemental briefing, you agree that the defendant, Collins, should be dismissed?
As to that issue that you raised, he was not properly served. That is correct.
So he's dismissed as a defendant here,
I believe so, yes, Your Honor.
but all the rest of them stay?
All the rest stay, and as I pointed out in our supplemental brief, it appears from the certified mail receipts that the same person signed for each individual at the same business address. And there's been no issue raised or fact presented that the person who signed was not authorized to do so for those individuals.
Can I just ask a follow-up on the Collins question that it's rattling around in my head? So if Collins was never properly served, then Collins was never properly made a party. So the district court didn't have jurisdiction over Collins. So then do we have a final judgment problem from the district court? Because then does the district court's order actually dispose of all claims against all named parties?
I think you could see it that way, Your Honor. I mean, candidly, the concern I have is if he's not made a proper party, then what notice does he have with regard to the claim? And were there any pleadings that he actually presented? So if he wasn't properly served,
I'm worried about our appellate jurisdiction, right? Which is to say, under 1291, we only have jurisdiction to review final decisions of a district court, and a final decision of a district court is a decision that resolves all claims against all parties. And if Collins was never properly served, I'm not sure how the district court could have resolved the claims against Collins. And if that's true, then I'm not sure how it could have entered a final decision.
yeah, I think that I understand your question. And so with regard to Collins, since the court didn't expressly address the fact that he was not properly served or dismiss him as a party, I think that he is still in the case at that standpoint when the court issued its opinion.
But I guess the court dismissed all claims against all defendants under this. I mean, this just gets us back to this question about whether railway labor, whether the RLA is a jurisdictional issue or not, because I suppose if it's a jurisdictional issue, it's fine because the district court is not required to prioritize one jurisdictional issue over another jurisdictional issue. So even if it doesn't have personal jurisdiction over the defendant, Collins, it can dismiss the claims against him for lack of subject matter jurisdiction. But if, on the other hand, this isn't jurisdictional and what the district court actually did is enter a 12b6, I mean, you can't enter a 12b6 in favor of a party you don't have jurisdiction over.
Your Honor, in Giles, I believe that panel expressly stated, it grappled with that issue of whether or not the RLA is jurisdictional and concluded that it is.
I thought what Giles said is I thought in Giles we said we didn't have to decide whether it was jurisdictional or not.
I think they concluded that it is. I would have to pull my version of the case.
We have a threshold issue here of subject matter jurisdiction. And, until we address that, I'm not sure how we can go any further. And you've got a Supreme Court that is very, very pro-arbitration. And you've got a section of the Railway Labor Act, which 151A, which the statute emphasizes the prompt and orderly settlement of all disputes arising out of grievances or interpretation of collective bargaining agreements. And that just screams loud and clear that the case should go to arbitration for several reasons. First of all, the words prompt and orderly are far more likely to be resolved through an arbitral process than through litigation all over the country. And second of all, you're talking about all disputes going out of grievances or interpretation of the collective bargaining agreement. And the collective bargaining agreement here has a detailed grievance procedure. And why shouldn't that be used?
Your Honor, I completely disagree with you with regard to the collective bargaining agreement. In fact, I think that the Amtrak policy and procedure for testing individuals was never collectively bargained by the parties. The only thing that was collectively bargained by the parties was the discipline. The SMART agreement expressly talks about discipline, and then there are 2 waiver provisions. Those are both things that are subject to the grievance policy and
Well, but
procedure.
the collective bargaining agreement covers rules and working conditions.
It's not that, I think that that argument can only go so far where, in fact, I believe that Amtrak there is at least one public statement that I'm aware of that Amtrak's, one of their counsel has expressly said that the policy and procedure for the workplace drug testing was a management rights implementation. And when management rights are implemented and the union takes no additional steps to maintain status quo or to bargain those particular benefits, then it can't be part of a collective bargaining agreement. It's completely removed. Even in the...
I take it your position here is that the collective bargaining agreement simply doesn't apply.
It doesn't apply to the claims that I think that she was trying to assert post the waiver provision, which she was subject to, and what did fall under the collective bargaining agreement.
As far as your Title VII claim,
That's correct. Those things that she brought under Title VII,
your argument is, when it comes to the Title VII claim, the collective bargaining agreement simply isn't part of the resolution.
to the extent that it does not require the interpretation of that collective bargaining agreement, which her claims do not, the claims specifically about the discriminatory application of the drug testing policy and procedures, which are not incorporated in that collective bargaining agreement. The only thing in the collective bargaining agreement has to do with the agreement between the parties about waiver, the agreement between the parties about there's a bypass provision where someone is viewed to be under the influence and can be removed and put into an EAP program without having to go through the testing, or the situation where they have violated those provisions and are subject to discipline such as suspension, which she was. And she went under a grievance procedure for that suspension. But her other claims, and it's a pro se complaint, and so it's very, very near the end. She complains about the application several times. I think one time she says at least 6 times, another time she says at least 7 times, that the application of the testing procedures were discriminatory. And that's what is, I believe we are saying, we are arguing are outside the reach of the RLA preemption.
Excuse me, Counsel. Any complaint about discipline can be reframed through artful pleading as discriminatory. Any disciplinary action at all can be repled artfully as being a discrimination claim.
But Your Honor, I think you quoted earlier that to the extent that the parties have agreed that it's going to be subject to arbitration, that whether I plead it artfully or not, that particular claim, in this case, the suspension, the discipline, is going to be subject to arbitration. I have no argument with that. And what I'm suggesting is that what she was trying to plead she was trying to plead 2 different things. One that I would say is absolutely preempted, to the extent that she was trying to say that the suspension was discriminatory. She couldn't do that. That was already under the SMART agreement. It's under those provisions that the parties have
But collective
negotiated.
bargaining agreements are not generally that detailed. They talk about workplace conditions and grievances.
In
They
this
talk
case, it
general
is,
terms.
though, Your Honor, and I have to respectfully disagree. In this case, as it relates to the issue of drug testing and the use of drug and alcohol, the parties have been very explicit about what is going to be covered under that collective bargaining agreement. And the policies and procedures for testing are not. They have not been negotiated. Amtrak had created them. Amtrak manages them. Amtrak, in fact, modified them in 2019 and expressly said in an ABA article that those were implemented through management rights and not negotiated by the parties. So,
Thank you, Counsel. You have some rebuttal time, too. Ms. Davis would be pleased to hear from you.
Thank you, Your Honor. May it please the Court, I'm Allison Davis, representing the National Railroad Passenger Corporation, also commonly known as Amtrak. I'd like to address what Ms. Polk's claim is about here.
Well, tell us, what do we do with Mr. Collins?
The court does not have personal jurisdiction over Mr. Collins. He was never properly served. There's no evidence in the record that he was ever properly served. All that the appellant has is that someone at Amtrak signed for certified mail. There's nothing showing that that individual was authorized to accept mail for Mr. Collins, or that Mr. Collins was ever made aware of delivery of such a package.
But then why doesn't, sorry.
So what does our opinion say about him? When you're the judge writing the opinion, what do we say about Mr. Collins?
That the decision of this court does not apply to Mr. Collins because the trial court could not have adjudicated his rights.
But that's the problem for me. If we say that, then there's no final judgment. Like, there seems like a dilemma here. Like, either this decision on appeal applies to Mr. Collins, or it doesn't apply to Mr. Collins, in which case I don't think we have a 1291 final judgment here. Now, so two things on that. Do you agree that in Giles, this court specifically said we were not deciding whether the RLA preemption is jurisdictional?
Yes, I agree.
Footnote 3 specifically says we are not making that decision. Okay, so we have to assume that it's at least possible that it isn't, unless we decide that it is, but we'd have to decide that it is. So the only way I can think of how this isn't a massive finality problem is something like this. The district court in its footnote said, I construe this motion to dismiss be filed on behalf of Mr. Collins as well, right? That's what it said about this.
Yeah.
Okay. Well, you can consent to personal jurisdiction by voluntarily appearing in court, right?
Correct.
So, for example, if Mr. Collins, represented by his own counsel, had filed a motion to dismiss that did not allege a personal jurisdiction or service of process defense, that motion would be deemed to waive a personal jurisdiction or service of process defense, right?
Correct.
Okay. So if the district court construed the motion as being on behalf of Mr. Collins, the district court, I guess, also concluded that he waived any personal jurisdiction or service of process defense, right?
Right, but Mr. Collins never appeared before the trial court.
This was kind of trying to help you. I guess I'm saying, if I go with your theory that he never properly appeared, I don't think there's a 1291 final judgment.
But the court wasn't in a position to adjudicate his rights if he was never made a properly made a
100%,
party.
but we under 1291 only have jurisdiction if the district court adjudicates all claims against all parties. So I don't see how the court cannot have adjudicated Mr. Collins's, the claims against Mr. Collins, and still issued a final decision under 1291. I think it's one or the other.
I believe that the court thought it was in a position to adjudicate his rights even though he had not entered his appearance, and
Well,
therefore it
not
was
to
a final
belabor-
order.
Not to belabor this point, but what did Amtrak represent to the district court as their authority to act on behalf of Mr. Collins?
We did not make any representations with respect to Mr. Collins. It was Mr. Lamontagne who we did. We didn't make any representations as to Armstrong, Stencil, or Collins. Would you like me to proceed?
Sure.
Any further argument on the jurisdictional issue needed?
Well, I guess, does Amtrak have a position about whether, since we didn't decide this in Giles, does Amtrak have a view about whether this is a jurisdictional rule, the RLA preemption, conflict of laws, whatever we call it?
Yes, that it is a jurisdictional issue.
So you want us to, if we reach that, you would like us to say what the DC Circuit said about it?
Correct. And going back to the nature of appellant's claim, it's more than just challenging Amtrak's drug-free, alcohol-free workplace program.
Could you put that microphone right in front of you? I want to be sure I hear what you say.
This case is not just about a challenge to Amtrak's drug and alcohol-free workplace program. If you look closely at the complaint that Ms. Polk filed, including all of the supplemental filings, she repeatedly states that she is upset with Amtrak because she believed that she was being tested beyond the bounds of the waiver agreement that she had signed in May of 2019. The waiver agreement arises out of rights that Amtrak has to discipline union employees through the SMART collective bargaining agreement. In order to determine whether or not her rights were violated, the court would have to examine the collective bargaining agreement. This is very different from if Ms. Polk had chosen to challenge the initial return to work drug test and challenge whether or not Amtrak was targeting her for discipline because of her shy bladder as compared to individuals not within her protected
But
category.
doesn't she also allege that, in addition to all that, that I received this treatment of having to undergo additional testing because I was discriminated against because of my race?
She does in some communications late in the process of challenging the return to work drug testing. But if you look at all of the communications, they are about the fact that she believed that the waiver agreement had expired and Amtrak did not have the right to further test her. So that goes back to examining what are the employer's rights under that collective bargaining agreement with respect to waiver agreements that are covered by the collective bargaining agreement and any past practices with the union as to the interpretation of waiver agreements and whether or not they can be extended if there's an expiration date.
Is the drug policy that Amtrak adopted, is that part, is it your argument that that's part of the collective bargaining agreement?
Yes, it has to be part of the collective bargaining agreement because Amtrak cannot unilaterally impose any working conditions on union employees. And clearly there was some negotiations that went on because there are side agreements relating to the Rule G program and the prevention program. So in fact, there were negotiations between SMART and Amtrak as to the drug testing program and how it applied to union employees.
Can I ask you what happens? Let's assume this case does go to arbitration. Can Ms. Polk, before the arbitrator, say, I believe that Amtrak discriminated against me based on race in violation of Title VII? Can you raise a Title VII claim based on race discrimination before one of these arbitrators?
There's nothing that prevents an employee from doing so.
And could the arbitrator give her monetary damage? I mean, Title VII allows monetary damages. Could the arbitrator award the remedies that Title VII authorizes?
Yes, the arbitrator could.
And then what happens if she disagrees with the I mean, I guess I'm more familiar with the Federal Arbitration Act. What happens if the arbitrator does something she thinks is egregiously wrong? Is there judicial review of that?
There's not judicial review. There is review by the Public Law Board. So it goes through the grievance process. Then if she's dissatisfied with that result, it goes to a Public Law Board.
Even if she raises a Title VII claim and she thinks the arbitrator got her Title VII claim wrong, there's no judicial review?
Not if you're following the process under the collective bargaining agreement and the RLA.
The Supreme Court has dealt with a great many workplace discrimination claims, and they dealt with it with the ADA and the rest, and what they said is that the presumption in the FAA, which is strongly in favor of arbitration, does not go out the window simply because it's a discrimination claim. And in the way back when, in the early 1970s, the Supreme Court was more sympathetic in the Gardner-Denver case to the view that if it's a Title VII claim, can come into federal court. And since that, there has been no decision repudiated as often as Gardner-Denver. And they've taken every chance they have to say that the normal presumption of the FAA applies to workplace discrimination complaints. And here you have a grievance procedure that is set up, and you can circumvent that by just saying every grievance decision that Amtrak makes is somehow discriminatory, and you've bypassed the purpose of the RLA, and you've bypassed the grievance procedure, which is set up in the collective bargaining agreement, and the whole purpose of Congress to provide arbitration of some of these workplace disputes, because it was a better promise of stability in labor management relations. And of course, the classic trade-off is unions give up their right to strike, and the employer agrees to submit to arbitration. And that's the classic trade-off. And the Supreme Court has blessed that. And I don't think anybody here would say that the constant litigation of these kinds of things is going to contribute to the prompt and stable and orderly settlement of disputes growing out of mass transportation. And you've got the expression of Congress in the FAA, you've got the expression of Congress in the RLA, you've got the expression of the Supreme Court, and opinion after opinion after opinion, and those have a single thrust, which is, this is classic arbitration subject matter.
I agree, Your Honor, and especially in a case like this where Ms. Polk will be able, if she were to prevail through the grievance process, be entitled to all of the remedies that she could get under Title VII. So I don't see any prejudice to Ms. Polk's rights if she is compelled to grieve under the collective bargaining agreement, as opposed to filing a federal court action to protect her rights.
So as I understand one of your previous answers, if she's unsuccessful in the initial arbitration, there's an appeal to, it was a public law board?
That's correct.
But that's the final act, that, as you understand it, that's the final authority. There is no further appeal.
That's what I understand, yes, Your Honor.
I mean, the client here deserves a hearing. And it's important that Ms. Clark's client has a hearing. But nobody is trying to just shut off due process or close the door. Arbitration is a pretty good way of going about it. We have all sorts of arbitration panels. Not just anybody can become an arbitrator. They have to be pretty well qualified to become an arbitrator. The RLA has a whole system of arbitral panels for precisely this kind of thing. I mean, they're already set up, and they're chosen with scrupulous fairness for each side off of a list. Management gets one choice, and labor gets another choice. And then you have a third that is drawn from a more neutral list. But it's the American Arbitration Association and the RLA have set up a very detailed process for just this sort of thing.
And Ms. Polk could have had her hearing back in May of 2019 through the grievance process and not signed the waiver. She could have gone to hearing and challenged the decision, the notice that she received that she would be terminated, presented witnesses, presented documents before an impartial hearing officer, and there would have been a decision back in May of 2019. She chose to sign the waiver. The waiver determined the conditions for future drug testing. And once she signed it, afterwards she regretted signing it and decided to bring a Title VII claim. And she should not be able to end run the process.
Can I just ask you about what the nature of this doctrine is? I saw some cases refer to this as preemption. Do you agree that this isn't preemption because we're talking about two federal statutes? We don't say that one federal statute preempts another, do we?
No, we don't. We say preclusion.
We say that RLA precludes you from suing in court for things that come within the terms of the collective bargaining agreement? Or some?
It precludes bringing in federal court claims under federal statutes, claims that are grounded in the collective bargaining agreement. It preempts state law claims that involve collective bargaining
And does that difference matter? I guess the reason I was thinking about why this matters, right? So in the federal-state context, there is a presumption against preemption. But in the federal context, we don't have that same kind of presumption, do we?
In the federal setting, there's a presumption against.
Against what? Implied repeal? Against implied repeals?
Right.
And I guess we'd have to do that, well, because Title VII is obviously the later enacted statute here.
That is correct. But here it's clear, based on the allegations in the complaint and the supplements to the complaint, that the claim is going directly to the waiver agreement, which is governed by the collective bargaining agreement. So any court hearing her claims will have to interpret the application of that collective bargaining agreement.
Right, so just to build off what Judge Agee was saying in terms of what you would actually say in explaining this doctrine, it would be, although Title VII is the later enacted statute, we do not understand for Title VII to modify the normal rule that if you have a claim arising out of the collective bargaining agreement, you have to bring it in this arbitration. Doctrinally, that's how that works.
Correct.
So could I just ask you on that front, what term in the drug policy would a federal court have to interpret in order to adjudicate her claim?
It's not a term in the policy that would have to be interpreted, because Ms. Polk's claim is not about the application of the drug-free, alcohol-free workplace program. It's about her waiver agreement and whether or not under her waiver agreement, Amtrak was permitted to continue to test her.
Okay, I guess, fair enough. So I guess it's a broader question then. What I read Giles as saying is the question is, would a court, in order to resolve this claim, have to interpret the collective bargaining agreement? What part of the collective bargaining agreement would a federal court hearing her Title VII claim have to interpret?
It would be the policy, which we believe is incorporated into the collective bargaining agreement.
Sure, but what language would a federal court have to say what that language means in order to adjudicate her race discrimination claim?
The frequency of testing.
The provision about how frequently you're allowed to test.
The frequently and also the discipline provision, which specifically states that for union employees, it's governed by the collective bargaining agreement.
One thing that occurs to me is that in this area, aren't preemption, aren't preemption and subject matter jurisdiction and the lack of subject matter jurisdiction really one and the same? Because if it is preempted, or if the case has to go to arbitration, the federal district court simply lacks subject matter jurisdiction.
That is correct, Your Honor.
And that seemed to me, there seems to be a jurisdictional question at the heart of this whole case, but it's one of subject matter jurisdiction. And the district court doesn't have, if the district court doesn't have subject matter jurisdiction, it has no authority to pronounce a final judgment or an interim judgment or anything else. The only thing it can do is dismiss the case and send it over to arbitration as a matter of just a basic absence of federal court jurisdiction.
And that's why I am requesting that you affirm the lower court's decision.
So how does the Hawaiian Airlines case factor in your view?
The Hawaiian Airlines case provides a framework for analyzing these types of cases, which applies whether you're talking about RLA preemption or RLA preclusion. So as they've held in that case, if it requires interpretation or application of the collective bargaining agreement, the claim is precluded.
And it says there's been a Supreme Court decision that says minor workplace disputes go to arbitration.
That is correct. And
your view is that this falls into that classification?
yes. See, my time is up. Unless there are any
Well, we
further-
appreciate it. Thank you very much.
Thank you.
Ms. Clark, you have
Yes.
some
I do.
rebuttal.
With regard first to the last point that was made, the RLA makes it clear that minor disputes go to arbitration if it requires an interpretation of the collective bargaining agreement. It just doesn't say it automatically goes to arbitration. If it doesn't require an interpretation of the collective bargaining agreement, I believe that a federal statute can be used by an individual employee for purposes of enforcing their rights. And neither the Hawaiian Airlines case nor does this court's decision in Giles suggest otherwise.
Well, your opposing counsel says that the drug policy was negotiated and incorporated into the collective bargaining agreement, which seemed to be a question of fact. So that seems to contradict what you told us before.
Yeah, it is a question of fact. It was not discussed in the district court below. And I believe the reading of the SMART agreement does not incorporate Amtrak's policy, as I stated before, and will supplement under Rule 28, I think Rule 28F, there is a public statement by Amtrak that policy was implemented under a management rights theory. If it's under a management rights theory, there is no collective bargaining that took place. The union did not have a role in agreeing to it. They have no role in its implementation. They have no role in when it's conducted. The only thing that it has a role in has to do with the discipline, which would include the waiver agreement. Now, I disagree with Appellee's counsel that the complaint that was filed by Ms. Polk was limited only to the waiver. She talks about in her pro se complaint that there were efforts after she successfully completed the waiver to test her that she thought were discriminatory on their face. Taking her complaint as a whole, one would have to read it that she is not just talking about the waiver. She makes it clear that she went through that process. She makes it clear that she was successful in completing that process. But what she's talking about afterwards is how the procedures are applied. And that is that's all Amtrak.
But why isn't this a classic working condition case, a minor working condition dispute that's covered by Hawaiian Airlines, and that the workplace condition is whether or not there is compliance with the drug and alcohol-free workplace program. And that is classic arbitration material. The working dispute is compliance with the drug and alcohol-free workplace program. And maybe she complied with it, and maybe Amtrak's wrong. And I guess one of the things that I'm particularly anxious to convey is that nobody is trying to, your client deserves a hearing. And there's absolutely no doubt about that. But, arbitration doesn't just slam the door on you. It gives you a hearing and it gives you relief and it gives you remedial possibility.
Your Honor, I guess I don't question what you're saying. I agree with you. But procedurally below, Amtrak didn't move to have this case put into arbitration. They just moved to dismiss it. That suggests to me that they didn't believe she should have a hearing at all. I would, believe me, if they had said, okay, this should be arbitrated, and therefore we move to dismiss this case and in order for it to be arbitrated, which was not the motion that was filed here.
If they want to dismiss it at the outset, isn't that the same thing? If they want to dismiss it,
If they want to
fly out, where would it? Nobody wants your client thrown out. Thrown out.
I think Amtrak exactly wanted my client thrown out because traditionally, when you are facing these issues and there's a question about whether or not an arbitration agreement applies, defense counsel will say, plaintiff counsel, we understand this claim, but this claim is covered under the arbitration provision that's in this collective bargaining agreement.
We can make very, very clear that this is not going to be a question of freezing your client out. We can have, the Court of Appeals does it all the time, remands with directions that the matter be remanded to arbitration. And because it is a matter of subject matter jurisdiction, the Court of Appeals can take it up sua sponte and issue directions to say there's an absence of subject matter jurisdiction, send it over to arbitration. And we're free to bring up subject matter jurisdiction all the time. But the bottom line is, you have a client and your client deserves a hearing. Absolutely. And it might surprise you that you do very well and succeed in arbitration. That would make everybody happy, huh?
Well, I would like to think so, Your Honor, but I don't think that's always the case. And separately, again, I believe that with regard to the facts in this case, that there was no presentation of any collective bargaining agreement that expressly talked about the application of the testing policies and procedures. It's a separate document. It is in the control of Amtrak and was never collectively bargained. And because of that, I don't believe that the RLA precludes my client's Title VII claim and that she could move forward in front of the federal district court.
So is your concern that if we were to remand it in direct arbitration, that Amtrak would then say this is not covered by the collective bargaining agreement and therefore it's not subject to arbitration?
I have no idea what arbitration, they didn't raise an arbitration provision. They didn't point to one in the collective bargaining agreement that they believe that applied. The provisions that are outlined in the appendix.
I understood, maybe incorrectly, your opposing counsel's argument to contain the admission that arbitration was available.
I hear the argument, but what I've read in the appendix, especially at 290 to 296, is the SMART agreement, which talks about the disciplinary procedures when someone fails to comply with the drug testing or fails a test. The bypass procedure at 297 to 299, which talks about if someone is seen on in the workplace to be subject to drug or alcohol, that they can be removed for purposes of going through an EAP program, and the waiver agreement, where if there's a violation or there's a failure to test, that you are able to go under the waiver agreement, not lose your job necessarily, and be subject to an EAP program. All of those things are disciplinary issues. They're not going to what I believe is at the core of one of her many claims, okay, which is the implementation of the drug testing. She's saying the implementation of the drug testing is on its face discriminatory. Not the discipline, not anything under those three agreements that I've identified. The actual testing that Amtrak conducts, which is a document separate and apart from the collective bargaining agreement.
But the Amtrak has a contractual right to drug test a union employee, and then their program expressly provides that discipline for a union member will be determined by the applicable CBA.
The discipline, but
Right,
not,
but
not how, Your Honor, I'm sorry, but I just want to be clear. You're right. The discipline is covered by the arbitration, by the collective bargaining agreement, but not how Amtrak conducts testing, who they choose to randomly test.
I don't see how you can separate those two things, because it's like automatically, if you have a right, there are remedies and consequences for the violation of that right.
I see management right provisions in collective bargaining agreements all the time that remove any role that the union might have with regard to that management's right. And here, the drug testing policy and procedure is Amtrak's right as management. The union has no role whatsoever in the implementation of that testing. And as a consequence, it's very clear it was never collectively bargained. What's bargained is, yes, we have to comply with a federal regulation that requires us to make sure that there is safety on the job, in particular as it relates to our employees and whether or not they are under the influence of drugs and alcohol. But that collective bargaining agreement does not outline how the drug testing will be carried out. Amtrak took it upon itself to develop that policy and procedure. They continue to modify that policy and procedure without the input of the union.
Yeah, I mean, I think the question is whether you can split those two and sort of separate them, and I'm not at all certain that that's practical.
But the union has made no statement or has not made any suggestion about how it's going to be conducted. That suggests to me that only the employer is involved in that testing.
Thank you very much.
Thank you, Your Honor.
We very much appreciate your argument.
Thank you, Your Honor. Good morning, and may it please the court. I'm Emily Harrell, and I'm here on behalf of appellant Elliott Graham. Under the certificate of appealability that was granted in this case, the question for this court's consideration is whether the district court erred in determining that Mr. Graham's 924C conviction was based on both kidnapping and carjacking. A record review based on the Crawley decision indicates that his 924C conviction was based on kidnapping only, and therefore the district court erred in determining that his conviction was based on both kidnapping and carjacking. If you look at the record documents in this case, Mr. Graham pleaded guilty. The indictment itself does not specify what the underlying 924C crime of violence was. The only 3 counts in the indictment that have the same date are counts 9, 10, and 11. Count 9 being the carjacking offense.
You say it hasn't been charged, but our law is pretty clear that something can be a lawful predicate crime of violence without being charged.
Well, that's absolutely true, Your Honor. But the government has not taken the position in its briefing that some other crime of violence was perhaps underlying the 924C conviction. They have indicated that it was either the carjacking or the kidnapping. And I think that that failure to brief something else certainly limits them here before this court.
So was the carjacking count, was that dismissed?
Yes, sir. As part of the plea agreement, count 9 was dismissed, which was the carjacking count, and also count 12, which was a felon in possession count. So as part of the parties' agreement, they did decide to, he did bargain for their dismissal of count 9. And even though the plea agreement itself does not specify that the 924C count is based on the kidnapping, the dismissal of the carjacking was part of the parties' agreement. So the indictment does not directly specify, the plea agreement does not directly specify. It's only when you get to the plea colloquy that it's quite clear that the parties' agreement was.
The plea colloquy is a Shepard-approved document?
Yes, sir. Absolutely.
So what's wrong with the district court relying on the plea colloquy?
There's nothing wrong with the district court relying on the plea colloquy, but the plea colloquy establishes that the parties' agreement was, and that he admitted only to the kidnapping being the underlying offense. And I say that for 2 reasons, well, for several reasons. But primarily because when the assistant U.S. attorney was summarizing the plea agreement, he indicated that the 924C count was based upon the kidnapping. And that's on page of the joint appendix, page 38, where he says, Mr. Graham is going to plead guilty to counts 10 and 11, and count 10 and 11 of this indictment, which charges kidnapping, as well as a 924C violation in connection with the kidnapping. So as an officer of the court, he stands up and says that this is the parties' agreement. The court then asks Mr. Graham, is this your understanding of the agreement, on joint appendix page 40, and Mr. Graham says, yes, it is.
The facts on the, unlike some other cases, the facts of the carjacking and the kidnapping are rather intimately intertwined.
Well, they are intimately intertwined, but
This is all committed on the same time, same place, probably the same manner. The only difference was that one involved a car, and I don't think that there's any dispute, is there, that the car was driven off the property in an attempt to get the rim or whatever of the tire. I mean, there's a huge degree of overlap.
there is a degree of overlap, Your Honor, and this is where the government runs into its major problem. When presenting the facts to form the basis of the plea. The government outlines the facts, and then it says, government counsel says,
Is this the car moved in interstate commerce, but that doesn't matter here because
yes,
this
sir. This is on Joint Appendix, page 52. And according to the defendants, he had the gun, and they drove the car over state lines, which satisfies both the kidnapping and carjacking. And government counsel says, and the car was made outside of South Carolina, but this is a kidnapping, so it doesn't matter. And the government has presented no...
Well, in fairness to the district court at that time, based on the law at that time, there was no reason for it to make a finding as to carjacking, since kidnapping was sufficient.
Well, that's true, but it's also Mr. Graham's position, and certainly based on this record, that the parties' agreement was that the 924C count was based on the kidnapping only.
Well, maybe so, but that comes back to the basic point that these predicate crimes don't need to be charged and they don't need to be convicted. All they have to do is that the district court must satisfy itself that the elements of the predicate can be proven beyond a reasonable doubt. And it's entitled to take a fresh look at that without regard to the procedural history. And it is faced flat out with the question of whether the elements of a carjacking, and everyone agrees that the carjacking is a COV, and straightforwardly, the question is, can the elements, could the government, can the district court satisfy itself that the elements of what is indisputably a COV can be proven by a reasonable doubt?
And I think that would be perfectly reasonable, Your Honor, at the original guilty plea. If the government had abandoned its this interstate commerce element of the carjacking, and then the district court and the parties had said...
That gets back to Judge Agee's point, because there was no reason to make a fuss over those or get involved in a big dispute over those if the kidnapping alone would suffice. But then when the kidnapping was found not to suffice, it put the carjacking back on the table.
Your
and then
Honor,
you can go to it.
with all due respect, I don't think at this point, 17 years later, that the district court can go back and look at the record. This record, where the government specifically abandoned the elements of carjacking and say, well, oh, by the way, he also committed carjacking. What if there had been a law passed in the meantime which Mr. Graham's actions also satisfied? Would the district court then be able to say, well, you know what, I've decided that that qualifies too, so, 2255 dismissed? I don't think that's the way our system works. I think at your guilty plea, you have to have notice of the elements of the crimes you are admitting that you committed. And it's true that the government is not required to charge him with a count. It could have stood up and said, kidnapping, and oh, by the way, it also satisfies carjacking. At that point, whatever Mr. Graham would have said would certainly now come back to haunt him.
Well, if we, just assuming that we agreed with your argument here, what would happen going forward?
For Mr. Graham?
Yes.
I think he would be entitled to relief, which would mean vacation of the 924C count and resentencing on the kidnapping only. And for Mr. Graham, it would essentially mean a time-served sentence because he's very close to serving the 260 months. And it would change his guidelines, certainly, to begin with, because he would not be a career offender, because kidnapping would not be a crime of violence. So the base offense level, or the total offense level, from which the district court would then calculate his sentence, including a substantial 5K1 that he earned at his original sentence, would be included, which would almost certainly give him a time-served sentence.
So what's your best case backing you up? Your best precedent backing you up, case law?
Well, I would certainly say that his, if you take this position that this court can go forward, or the district court could go forward and find that the carjacking applied without him having been informed of all of the elements of the true elements of what he was admitting, I think his plea would not be knowing and voluntary.
What I meant was,
Sorry.
what case, decided case, best supports your position?
As far as the examination of the record, in this particular instance, I do believe the Crawley decision, is the most informed basis that we would look to as to what this court would undertake in its analysis of the district court record. Thank you, Your Honors.
Thank you.
I'll go ahead. I'll reserve the balance.
Sure.
Good morning, Your Honors. My name is Bill Watkins. I represent the United States in this matter. Your Honors, this case presents a fairly simple question to determine, and that is whether the district court clearly erred in finding that Mr. Graham's 924C plea was based in part on carjacking. For you to reject the district court's order, you would have to have a definite and firm conviction that an error was made in finding the facts here and that the decision was unquestionably erroneous. And while Ms. Harrell makes some very good points in her brief, the government does not believe that we can get to that level in rejecting what the district court did. After all, the district court was intimately familiar with this case, having tried co-defendants, taken the plea.
Mr. Watkins, can I ask you, you just raised something I was going to ask you about.
Yes, sir.
One way I guess sort of like abuse of discretion, a district court commits clear error if it makes an error of law, right?
Yes, sir.
So why is it not an error of law on page JA75 where the district court said it is also instructive to consider the convictions of petitioner's co-defendants? I don't know how you can possibly consider that in making the Crawley inquiry.
Your Honor, the way I read that is the district court was just looking at what happened with other co-defendants.
You mean another way to describe what that is the district court looked at evidence outside the record in this defendant's case to decide the facts of this defendant's case?
No, sir. I think what the district court was doing, Your Honor, was simply showing in its order that it had treated everyone with equity in this case and had fed everyone, as we say, from the same spoon. I do not think it was...
Let me ask you this.
Yes, sir.
If this was properly interpreted as the district court saying, in finding the facts of Mr. Graham's case, I am considering facts from outside the record of his case and are in the record in his co-defendant's case, do you agree that would be legal error?
Yes, sir. But, Your Honor, this whole looking at the PSR and other things, well, first of all, we have talk about record documents. I've never found a case that describes what record documents are. Crawley doesn't state that.
It lists 3, but it doesn't purport to say those are an exclusive list?
Correct, Your Honor. I mean, I think, for example, had the PSR indicated without equivocation that carjacking and kidnapping were the predicates to which he pled, I think that would be relevant to consider, especially if there was no objection to the PSR. But I think that's beside the point, Your Honor. It's just we don't know exactly what record documents are, but we do know from the district court's orders that it considered the facts of the case based on the plea colloquy. Yes, it cites a PSR, but
You haven't argued that the original PSR in this case sets out a carjacking predicate.
no, sir. I will say the original PSR, it contains the carjacking facts, but as to your point earlier, Judge, no one at this time ever imagined we would live in this day of legal scholasticism where kidnapping's not a crime of violence.
Okay, well, I understand there is some intuitive force to that argument, but this gets me back to what's good for the goose is good for the gander. This happens to criminal defendants all the time. Criminal defendants say, I couldn't possibly have known that because the law changed, and now it's like more favorable to me than it was. We say defendants have forfeited and are stuck with the consequences of legal change all the time. Why does the government get a different rule that says when the law changes in a defendant's favor, the government can go back?
Oh, I would not ask that you do that, Your Honor.
So then I think for purposes of this case, we have to assume this case as if at the plea colloquy it was clear that kidnapping was not a crime of violence, because otherwise we're giving the government the benefit of an intervening legal change we would never give a criminal defendant the benefit of.
Your Honor, as to use my term earlier, you should feed everyone from the same spoon.
So then I think we have to assume that at the time of the plea colloquy, it was legally clear that kidnapping was not a crime of violence, and we have to ignore the fact the law changed. Because this defendant preserved this claim. This is not a forfeited argument, right? Normally the government wins these cases because you win under plain error. But here this is not forfeited. This is preserved, isn't it?
Yes, Your Honor, we've not raised any forfeiture here. This court allowed him to proceed with his 2255. But, Your Honor, my point is this. The district court found, based on examination of the record documents, the facts, the factual basis, the indictment, all that together. And mainly, I think the district judge rested his opinion on the plea colloquy.
Great. So where in the plea colloquy does Mr. Graham admitting to having the intent to cause death or serious bodily injury, which is an element of carjacking but is not an element of kidnapping, where does he ever admit that?
Your Honor, the facts that were given when you have a gun, you point it at someone, you pistol whip, you threaten to take them in the woods, pour gasoline, and burn them, Your Honor, that's
a statement about what he threatened to do. I mean, I think the language of the carjacking statute is really weird because it doesn't say, so like think of robbery where I basically use or threaten to use physical force. If the element of carjacking was that he used or threatened to use physical force, like it would be under robbery, I think you'd have a much stronger argument. But that's not what this element is. The element is about his intent to do something. And where in the plea colloquy does he admit to having that intent?
All right, the element is with intent to cause death or injury. He caused...
Right, not threaten to do so, intend to do so. Where does he admit that he intended to do that?
I believe in the plea colloquy, it determined that he pistol whipped a man, he injured a man. Your Honor, these actions, clearly he had the intent to cause injury. He caused injury.
Let's take another. Where in the plea colloquy does he admit that this car moved in interstate commerce?
Your Honor, two things. One, Mr. Graham would argue that the government abandoned the commerce issue. I would not agree with that. I think the AUSA, again, we don't have an affidavit or anything from him, but when we're looking at findings of fact, and the district court looked at this same statement and did not find that it caused some sort of voidness of the element, but the AUSA did say that, and the car was manufactured outside of South Carolina. Did he follow up? But this doesn't really matter because it's kidnapping. I think the inference there, Your Honor, and there are multiple ones, but a strong inference is that in this case, he was thinking of the substantive offense because they had put the elements of kidnapping on, and that really didn't apply to kidnapping.
No, but I guess what I would just say is, so ultimately at the end of the day, the counsel's statement isn't evidence. What's evidence is what the defendant admitted. And when counsel says it traveled interstate commerce, but forget it, that doesn't matter because it's not kidnapping. And then when the judge looks at the defendant and say, was that an accurate summary? and the defendant says yes, I don't think there's any way to read the defendant's statement other than I'm admitting to the things the prosecutor said mattered. I'm not admitting to the things that he didn't say mattered.
Yeah, I don't know if I would agree with that statement insofar as when the judge asks, do you agree with the prosecution's recitation of the facts, that I don't see, well, yes, everything that he said matters, but I don't see that sort of reservation. Besides, it's clear from the record, Your Honor, that this car did travel in interstate commerce from South Carolina to North Carolina.
How do I know that? I know it because an AUSA just asserted it and then immediately said that doesn't matter.
No, Your Honor, he said it doesn't matter the manufacturer. I'm talking about during the crime, it traveled.
How do I know that?
The AUSA put that on the record, Your Honor.
Counsel just asserted it. That's how we know that?
That's how we do guilty pleas, Your Honor, is I give a statement of the facts. I assert what facts are, and I don't put up evidence, and a defendant the judge says, Mr. Defendant, you agree with prosecutor's statement of the facts? And he either says, yes, sir, or no, I don't, I disagree, blah, blah, blah.
So is it clear that the perpetrator here pistol whipped the victim?
Yes, sir.
Is that in dispute?
No, sir.
How does one pistol whip a victim and point a gun at a victim by accident without intending to cause injury? I mean, you know, it's a basic criminal law that at some point the actus reus is impossible to commit without a commensurate mens rea.
I agree with you, Your Honor. Many times when
You don't pistol whip people by accident. You don't point guns at them by accident. That's right in the heart of the force clause.
I agree, Your Honor. I think the only inference from the record is he had to have that requisite intent. I mean, Your Honor, in guilty pleas, where I do a lot of fraud cases, and it has to be with the intent to defraud. Rarely do I ever.
Yeah, I mean, intent comes. It comes into play with that exactly over and over with that kind of crime. Did somebody intend to commit a fraudulent act or something? But I haven't. It's a different bird to say, I pistol whipped the victim, but I didn't intend to. Or I pointed a gun at the victim's head, but I didn't intend to. And those, you know, you're not undermining mens rea. You are essentially underscoring it when you say this cannot possibly be committed accidentally.
Correct, Your Honor. There's, you don't accidentally pistol whip someone as you're demanding, where's that key so I can get those rims off your car, and you hit them, or you force them into a car with a weapon. And again, just the analogy I was going to use, just like in a fraud case, I might say that this bank teller took funds out of the till, which she was not entitled to, and used it for her personal use. And I might never say with the intent to defraud, because as you said, that actus reus is clear in such a case. Same here, Your Honor.
So those strike me as great arguments if either A, we had a trial where a jury was actually presented with evidence, or probably if this was a forfeited claim and we were dealing with like a forfeited rehafe error, right? But, so if all of this evidence is presented at trial and this argument had been preserved, I think under Nader we would say no reasonable jury could possibly have found that by doing this you didn't have the requisite. I understand how that works. Sure. And if it's a forfeited rehafe claim, I understand how it works to say the defendant has made no serious argument how any reasonable person would have ever found that they didn't have this intent, right? But this is a preserved guilty plea claim, right? In that context, aren't we really stuck with what the defendant admitted? Are we even, I guess this is a long lead into the question of, I'm not even really sure how harmless error works in the context of a preserved guilty plea claim. What is your best case for that? Because the cases you're citing are about trials, where things aren't submitted, where juries aren't asked to answer the question, but we say, sure, but given the evidence they were given, there is no jury that possibly wouldn't have, like Nader, basically, right? What is your best case about a preserved error during a guilty plea?
Your Honor, I'll be honest with you. My colleague cites Crawley. I think Crawley supports the government in this case. The district court followed the Crawley format, essentially. The only difference is that in the indictment in Crawley, in the 924C count, it lists the Hobbs Act charge as well as the drug offense.
I guess what I'm saying, it's a broader question. I think is that you often see in these cases people blur the distinction between jury trials and guilty pleas, and it strikes me that's very different. In a jury trial violation situation, the question is, you have a right, like, the reason a defendant who's sitting in jail after a jury verdict is because a jury of his or her peers found that they did something, right?
Sir.
And that's the justification for doing that. And sometimes we screw up, and sometimes we don't supposed to ask questions juries were supposed to. And when we do that, we say, well, but what if we had asked the jury the question based on the evidence before it? Is it pretty obvious what the jury would have said, right? Guilty pleas are different. If a person's sitting in jail after a guilty plea, it's because you admitted something. Not because the court found you did something, not because a jury found you did something, but because you admitted. The reason you're sitting in jail is because you said you did it. And it's hard for me to figure out how we can make inferences based on things he didn't admit to in the guilty plea context. Why isn't the answer, again, if it's forfeited, Rahaf tells us, you know this case I'm talking about. But in the guilty plea context where it's not forfeited, why isn't the government stuck with what he admitted and that's it?
Your Honor, I think that's the basis of our argument is he admitted the kidnapping elements. He admitted the carjacking elements.
You're saying he admitted things that, if true, necessarily means something else. That's different from saying he admitted that's something else.
Your Honor, the district court, we believe, properly found that when he pled guilty on this day, that he admitted to the predicates of kidnapping and carjacking.
Isn't the point of what someone admitted or what someone didn't admit, isn't that to a degree a finding of fact?
Your Honor, it's all fact-finding.
That's the point. Whether he admitted or whether he didn't admit, it's a finding of fact. It's a finding of fact. And there are constraints upon that finding of fact. You can only look at Shepard-approved documents, I think. But the district court basically essentially based its argument on the plea colloquy. Shepard says fine. I guess an indictment. Shepard says fine. An unobjected to PSR. Shepard says fine. I mean, the district court made a finding of fact consulting the documents that the Supreme Court says is perfectly right to consult. It didn't, and based on those documents, which alone, which form the basis of the district court's conclusion, are his views as to admission and the rest of it, are they clearly erroneous? That's what we're dealing with here.
Yes, sir. This is not a de novo review on the fact finding. A de novo review on the application of law, which is fairly easy in this case, is whether kidnapping remains a crime of violence. It does not. And does carjacking remain? And it is. And there's
a practical point here at the end. I don't think that any of us really believe that this individual did not engage in carjacking based on the whole record of this case. And the whole point of a 924C conviction and also career offender convictions and also the rest in one law, in one context after another, Congress has sought to penalize crimes of violence. And there is absolutely no dispute that this person committed a perfectly horrendous crime of violence, a horrible crime of violence. And, you know, at the end of the day, when you step back, you can spin the legal web so fine that you begin to do things such as allowing people who are indisputably culpable of horrendous acts, and which Congress and the Sentencing Commission and others have passed and made clear their intention to protect the public from this sort of misconduct. And we can engage in the finest web spinning, but there's a point at the bottom of it all that is faithful to congressional intent and to the Sentencing Commission's intent, to the Supreme Court's intent in preserving the force clause. And even though the residual clause was tossed out, the force clause was retained. And this is force. This is force clause stuff. Putting a pistol to somebody's head, pistol whipping. There's no vagueness problem there. It's force clause.
No, absolutely, Your Honor. This is clearly within the force clause, and you're right, Your Honor. There is no dispute. Essentially, we have one, to borrow a civil procedure phrase, common nucleus of operative facts on this event. The kidnapping, the carjacking, inextricably intertwined. It's one event, and it was...
That's the very problem with your argument to me, which is everybody knows he did it. I don't think that's how we do guilty plea review. And I guess you're asking me to just pretend. I looked at this again. The district court spent a paragraph and a half talking about his co-defendants. You have conceded it would be legal error to rely on that, and you're asking me to just pretend this doesn't exist, where the district court relies for a paragraph and a half on facts that involve his co-defendants.
Your Honor, he discusses the co-defendants, but again, my position, I think it's clear, he is just showing that he has treated everyone equally and fairly.
That's not a district court's job in deciding whether a sentence was legal or illegal. That's a question. Now, admittedly, if the question was about how much discretion I'm going to exercise under the guidelines, district courts don't have discretion to decide whether the ACCA is triggered.
Your Honor, I think the only illegal thing I see about this sentence is that the district court, rather than sentence him to consecutive time on the 924C, ran everything together. I see my time has expired. Is there any other questions?
One thing.
Yes, sir.
You know, the district courts say all kinds of things in sentencing. And, you know, they get up there and they wander a little bit and everything, but we give them a little bit. We cut them some slack on that. The point is, what motivated, what underlay the decision?
Yes, sir, and it was the plea colloquy, and I think the statements that Your Honor's colleague finds some trouble with, again, is really for the public and the parties to know he is trying to be fair.
This isn't at an oral hearing. This is a district court issues a written order that has a paragraph and a half that you think was legally incorrect.
I don't think it was legally incorrect. I think it was, first of all, it's a published opinion, so it is available to the public, showing that he is carefully considering this and trying to be consistent, and the basis of his decision, Your Honor, is that colloquy. And I think under the clear error standard, we cannot find that it was unquestionably erroneous to conclude that carjacking was a predicate. And I thank you, gentlemen.
Well, I have
Yes, sir.
like to get a word in edgewise here. So it strikes me that Crawley is a problematic precedent for you, because if I remember that case correctly, there was a conjunctively worded indictment to which the defendant pled guilty, and there was also an accompanying written statement of facts.
Yes, sir.
That was accepted. You don't have that in this case, so we're faced with the dilemma where years after the fact, the district court, albeit the same one that conducted the original proceeding, goes back and in essence looks at the record, and I don't think there's a dispute about what it could look at, and says, all right, I've looked at the record and I've determined that I could have found carjacking as a predicate back then. Therefore, I can find it as a carjacking now. But in doing so, there's no opportunity for the defendant really to contest that in terms of an evidentiary basis.
Yeah, I think
He can't put on any more evidence.
No, Your Honor, I think, first of all, is why Crawley was even a case set for oral argument. I don't know the inner workings of the court, but it was pretty clear because, as you pointed out, you've got the plea agreement mentioning both, the way it was charged mentioning both the crimes of violence, a much clearer case than this. I will grant that. However, I don't believe that the district court was simply scouring the record and trying to save a conviction. I believe he went back and looked at the record and found that this gentleman's guilty plea at the time involved both carjacking and kidnapping, and therefore it was proper to deny his 2255 motion based on the record documents.
So in order for us to affirm the government, we would look at the record and say that is a sufficient record to support a finding of carjacking.
That the district court's findings of fact were not clearly erroneous and supported carjacking because the car was manufactured outside the state and moved in interstate commerce during the crime. Either or.
Thank you.
Thank you, Your Honor.
"12 times during this guilty plea hearing, the district court mentioned kidnapping. 12 times. One time, the district court heard the word carjacking when it was talking about the cooperation aspect of Mr. Graham's plea agreement. 12 times, this district court connected kidnapping and the 924C count. On the joint appendix, page 53, when the district court at the guilty plea hearing is going over what Mr. Graham has admitted, Mr. Graham, you heard what the assistant U.S. attorney says you did in this case. You agree you participated in the kidnapping and used the gun? Yes, sir. Did you have the gun? Yes, sir.
Where are you reading from, counsel?
It's joint appendix, page 53.
I mean, what,
This is from the guilty plea hearing.
this is from the initial agreement?
This is from after the government has presented the facts to form the basis of the plea, after they have abandoned the interstate commerce aspect of the vehicle.
I'm talking about, is this the proceeding before us that we're reviewing?
Yes, sir.
Okay.
You participated in the kidnapping and used the gun? Yes, sir. Did you have the gun? Yes, sir. You and others kidnapped or took Mr. Brown into custody or took him, kidnapped him, forced him into a car in an effort to take these rims from him. Is that correct? Yes, sir. And you had a firearm in your possession when that was done?
I mean, so what does the fact that someone kidnaps someone doesn't make the act any less? Please let me finish. You
Yes, sir.
always seem to be real on the verge. You make a good argument, and I appreciate it, but you always seem to be just raring to interrupt. The fact that someone is kidnapped in the course of taking the car or put in the car doesn't make it any less of a carjacking. It makes it a more heinous carjacking.
Your Honor, that may be true. But what you stand, to Judge Hyten's point, what you stand before the court and admit for purposes of waiving your constitutional rights has everything to do with whether you have notice of what you are pleading guilty to. And in this instance, the government clearly linked the 924C with the kidnapping versus a carjacking. After they abandoned the element of the interstate commerce aspect of the car's travel, they could have very
But
well...
you're talking about notice. You have, at the sentencing hearing that's before us, you had noticed that carjacking was was the predicate on the table and could have been disputed, could it not?
The carjacking was not an aspect of the sentencing hearing. They found him to be a career offender based on the kidnapping. There may have been carjacking things listed in the pre-sentence report.
Well, but what I'm saying is it could be it's the predicate that is that issue.
Yes.
You're saying you couldn't dispute the predicate?
There was no need to dispute the predicate at the original sentencing because his convictions were kidnapping and the 924C, which was based on the kidnapping.
That's right, but we come back again to the point that the predicate doesn't need to be charged, or you don't need to be charged with the predicate or convicted with the predicate. What you need is that the question is whether the district court can find those elements reasonably beyond a reasonable doubt.
I don't think in a 2255 determined some 17 years after Mr. Graham's original conviction, whether the district court can then say, oh, by the way, you also admitted a carjacking. On these facts in this record, I think it's abundantly clear that the 924C was as to the kidnapping only.
You think it was clearly erroneous?
I do, Your Honor.
All right.
Thank you.
Thank you very much. I want you to know I appreciated your argument.
Good morning, Your Honors. May it please the court. My name is Umber Qureshi. I am joined by my colleague, Victoria Nielsen. We are pro bono counsel for petitioner Anthony White. I will be addressing Mr. White's claim regarding asylum and withholding, and Ms. Nielsen will be addressing his claim for a deferral of removal under the Convention Against Torture. At the outset, Your Honors, we wanted to acknowledge that we are not proceeding on the removability argument, which was section C in our opening brief. Because Mr. White has been removed to Jamaica at this point, the relief that we were requesting, which was termination of proceedings, is arguably moot and doesn't help him at this point. Unless the court has any questions about that point, I can start by addressing the agency's errors with respect to Mr. White's asylum and withholding claim.
Can I just ask you on that front then, does the fact that he has been removed render moot any of the other forms of relief that you're requesting, and if not, why not?
No, Your Honor. We're asking the court to remand on the other claims. We're asking this court to remand back to the agency. So, for example,
when you say the other thing, what thing is that?
Well, Your Honors, for the asylum and withholding claim, we have 4 arguments. One is that the BIA failed to apply the probable cause standard in addressing whether there are serious reasons to believe that Mr. White committed a serious non-political crime. it also incorrectly concluded that the evidence here supports a probable cause finding.
Sure, just a threshold question to follow up on what Judge Agee just said. And the answer may be yes, and if so, it's just my ignorance, and I apologize. Can the BIA grant asylum to a person who is outside the United States?
Yes, Your Honor. It can also remand back to the immigration judge to conduct more fact-finding if necessary.
No, I'm just focusing on whether the fact that he's not currently in the United States poses a problem for the BIA's theoretical ability to award asylum.
No, Your Honor. It's very routine for individuals to continue their proceedings while they're outside the United States.
Thank you.
So, Your Honors, the government here was not held to its burden to show that there are serious reasons to believe that Mr. White committed a serious non-political crime. The BIA, the IJ, and even the government concede that serious reasons to believe, the standard that is in the statute, is equivalent to probable cause. But, Your Honors, that was not the standard applied in this case. The IJ and BIA wrote that standard in their opinion, but they gave no reasons, explanation, or analysis of probable cause. The sole footnote in the BIA's opinion acknowledging that the probable cause standard applies is not enough. In addition to that,
Why not? I mean, if you have the evidence that would compose probable cause and the court finds, after analyzing it, that there is probable cause, what else do you say they should have done?
well, Your Honor, the agency here never actually analyzed the evidence under a probable cause standard. It failed to explain what probable cause is, what is required to meet probable cause. And instead, it's a little confusing from the agency's opinion, but it appears what the BIA has done.
Is it your view that the opinions needed to include a boilerplate paragraph reciting what everybody that's a first-year law student knows is probable cause? I mean, I'm not understanding exactly how you're connecting all that to an error.
Well, Your Honor, it needs to offer some reasoned explanation for its decision. In this court's recent opinion in Garcia-Hernandez from last year, the court addressed a similar issue where the BIA applied the incorrect legal standard in determining a motion to reopen, and in a footnote acknowledged that even under a different standard, it would be met, which is exactly what the BIA did here, saying that assuming probable cause is the standard, we acknowledge that, or we explicitly make a probable cause finding. In Garcia-Hernandez, this court, Judge Quattlebaum explained that there are two problems with the BIA's conclusion. First, the BIA does not explain how or why the non-citizen fails to meet that standard, and the BIA, quote, abuses its discretion when it fails to offer a reasoned explanation for its decision, distorts or disregards important aspects of the non-citizen's claim. So here, too, the BIA committed both errors through failing to apply the probable cause standard.
Well, help me to understand this. In this case, you've got 2 arrest warrants, an Interpol notice, an investigating officer's report, and multiple press documents that I think your client was the one who introduced. Why isn't that probable cause?
So, Your Honor, all of the evidence in this case actually turns on the reliability of yellow journalism. Just one day after a sensationalist and homophobic article titled, quote, "Pervert Pastor," appeared in the Jamaica Observer, arrest warrants were issued for Mr. White's arrest, which formed the basis for the publication of the red notice against him. Even DHS concedes in its brief to the BIA that the arrest warrants were, quote, based on information reported to news outlets. And so the evidence used to find probable cause here hinged on tabloid articles that were, one, based on hearsay. They do not identify Mr. White or the complainant by name. They do not contain any basis to inform whether the...
I thought he admitted the articles were about him. And isn't he the one who introduced them?
Your Honor, he introduced them for his claim, to support his claim for the Convention Against Torture. Now, for the asylum and withholding...
Once it goes into evidence, doesn't that open the door for the government as well?
Certainly, Your Honor, but for probable cause, it matters whether the evidence is reliable and whether it is particularized with respect to the person. So for the Convention Against Torture claim, even though the articles don't mention Mr. White by name, the broader public in Jamaica has associated these sensationalist articles to him. After the Jamaica Observer publicly outed him as gay, he began to receive death threats. But for the probable cause analysis, as we've pointed out, in addition to the issue of Mr. White not being named in the articles, there's no basis for this court to examine whether the sources are trustworthy or inherently reliable. They contain inflammatory language, and they all come from a single unverified news source. And this evidence is akin to, evidence that the Supreme Court itself said in Illinois v. Gates was insufficient to support probable cause. There, the police department received an anonymous letter, from an individual, that stated exactly where a couple in a particular neighborhood would go to buy drugs. And the Supreme Court held that the letter provides virtually nothing from which one might conclude that its author is either honest or...
Thank you, counsel. We'd like to hear from your co-counsel at this point.
Sorry. Thank you, Your Honor.
Thank you, Your Honors. Quote, I want you pilloried, exposed, filleted and salted, dragged across sharp razors, nails pulled out with hot tongs, and whatever else comes with the full measure of the law for such acts, end quote. That's one of more than 100 threatening messages Mr. White received after the Jamaica Observer articles were published in March 2020 that my colleague was just talking about. Whether or not you find that Mr. White committed, whether or not you find the agency had serious reason to believe that Mr. White committed serious non-political crime, the BIA failed to properly analyze his claim for deferral of removal under the Convention Against Torture. Under this court's rules, the BIA should apply de novo review to the legal issues in the case, and the BIA did not do that in this case. Instead, it thoroughly misinterpreted or misconstrued Mr. White's primary argument before the immigration judge. The BIA acknowledged that in the BIA appeal, Mr. White said that the IJ had erred by focusing narrowly on whether the Jamaican buggery law, which is still on the books and criminalizes consensual sex between same-sex partners, the BIA acknowledged that White argued that that was not the central part of his claim. The central part of his claim is that he would be tortured by community members and the government would acquiesce in that torture. However, the BIA never engaged with that argument. Instead, just like the IJ, it focused narrowly on the fact that the Department of State Human Rights Report says the buggery law is not generally enforced against consensual partners. But the BIA never addressed his central argument, which is that he would be tortured by community members. First, Jamaica remains one of the most homophobic countries in the world. DHS itself submitted a 2020 Department of State report by the Overseas Security Advisory Council that states, quote, there are continued reports of serious discrimination and abuse against LGBTI individuals, including assault, corrective rape of women accused of being lesbians, arbitrary detention, mob attacks, stabbings, harassment by hospital and prison staff, and blackmail. And the 2020 Department of State Human Rights Report acknowledges that an Inter-American Commission on Human Rights report says that the buggery law serves to legitimize violence against LGBTI people. Likewise, the amicus brief submitted by two of the leading LGBT rights organizations in the United States, Lambda Legal and Immigration Equality, go into further detail about how the buggery law serves as a way to legitimize the violence that happens against LGBT people.
So, on a general level, I hear you because I think that you've made a pretty persuasive case that Jamaica is unfortunately a homophobic society. But the problem is this particular case, the element that disturbs me about it is the fact that there was a molestation of a 14-year-old boy. And that's the object, that's the point of my concern. And you paint a very interesting picture of the general conditions in Jamaica. And I don't necessarily dispute that, but I thought it might have been better if you'd taken those general conditions down to the specific case and showed how, with respect to the cat claim, how this specific individual is likely to face torture, or how this plays out in the aspect of child molestation, because it would be a different case for me if the question didn't involve a 14-year-old boy.
Yes, Your Honor, I'm happy to respond to that in three ways. First, we've disputed throughout this case that there was any molestation of this 14-year-old boy. That was his testimony.
Fair enough, but doesn't that get you into the substantial evidence question?
So, second, for deferral of removal against under the Convention Against Torture, there is no discretionary element. Even if there was a conviction from the Jamaican court, which there's not, you must still consider whether or not it's more likely than not that he would be tortured in Jamaica. If he wins deferral of removal under Convention Against Torture, the United States government has the option to continue to detain him in the United States if they find that he's a danger to the community. So CAT doesn't have, it's not like asylum or where there's any kind of discretionary element. But in terms of the particularized torture fears in this case, the one time that Mr. White had any interaction with police in Jamaica when he was found kissing another man, the Jamaican police threatened him with arrest, extorted him for money, and
But didn't the arrest warrants and the red notice, they were fairly specific, and I thought that they went to a particular incident, identified time, place of the incident, and that incident involved a 14-year-old boy.
That is what the warrants say, but as my colleague argued, we don't believe those warrants have sufficient evidence in them. Mr. White is back in Jamaica. He's awaiting his trial.
That's a fair point, but isn't that something for the IJ and BIA to resolve rather than for us?
Well, Your Honor, the problem is that neither the IJ nor the BIA ever really considered Mr. White's central argument, which is that he would face torture from community members. He received explicit graphic threats of torture after these Jamaica Observer articles were published. And at the time that he fled Jamaica because he heard there was a mob outside his house, he personally knew of gay people who had been stabbed, stoned, run over with a car. So if there's that kind of animus against the, general LGBT community, imagine what the animus is like against someone who's accused of child molestation.
You don't think there would be similar animus, regardless of which country of the world you were in, if someone is accused of molesting a child, that the family, friends, and acquaintances of that person aren't likely to take some revenge action? I mean, that just seems to be not out of the ordinary in the human condition, whether it's right or wrong.
First, Your Honor, obviously we do not condone child molestation, and as we've said, we've vigorously argued throughout this case he didn't do what he's accused of. Right. That being said, the central...
Nobody says that you did, but it seems like your argument here hinges on an event where he doesn't identify any of the folks who were supposedly there, never reported it to the police, never sought assistance, and it seems to take it out of the context of what happened, because I could easily envision something very similar happening anywhere here when someone is accused of molesting a child.
Well, Your Honor...
I don't see how you can tie it to his sexual concepts that make it different from other human experience.
Well, first of all, again, under Convention Against Torture, unlike asylum, the fear of torture doesn't have to be tied to a protected characteristic. In this case, it is, and because of the homophobia in Jamaica, he's more at risk. But I think, and I realize I'm over time, what sets this case apart from what, could happen in the United States, is that the Jamaican government acquiesces in torture against LGBT people. It's very common for them to turn a blind eye, to even be complicit in torture against LGBT people. So of course he would not go to the police.
Getting down again to specifics, I mean, there's been no instance of past torture. And who specifically is going to do what?
Well,
Who is there someone out there that has a specific animus toward this gentleman, this individual? And who would acquiesce in it? And he's never experienced any physical mistreatment.
well, Your Honor, when he lived in Jamaica, that was before he was outed as a gay man. I mean, it's outside the record, but we've heard that he's actually currently in the hospital in Jamaica.
But I'm still trying to supply the specifics. Who exactly has it, has an animus toward this individual? Who are we talking about?
Well, Your Honor, there's not a requirement that Mr. White identify who the members of the mob outside
But
his
wouldn't
house
that be
were.
helpful?
Your Honor, when Vice President Pence was hiding in the Capitol during the January 6th riot, I don't think he knew who the members of the mob were, but he knew that his life was at risk. I don't think you have to identify who the people are that are trying to harm you to understand that they're there to harm you.
All right, we try to give you some extra time, and you also, both of you have some time for rebuttal.
Good morning, Your Honors. May it please the Court. Jeffrey Hartman appearing on behalf of the Attorney General. I'd like to quickly address the mootness point. The government is not arguing that Mr. White's removal...
Pull it up to
Yeah,
you.
pull that
Sorry.
mic a little bit closer.
Is that better?
Does it go higher?
Or
How about
stand
that?
closer or something.
The government is not arguing that Mr. White's removal has mooted his claims because his removal was involuntary, and he also has a motion to reopen pending with the Board of Immigration
I mean, the
Appeals.
general conditions in Jamaica for gays are pretty bad.
Yes, Your Honor.
It's a pretty hostile environment.
I would concede that. There's certainly evidence in this record of significant discrimination against gay men that's evidenced in the 2020 Human Rights Report and 2018 Human Rights Report, which the immigration judge and the board considered in denying Mr. White's claim. But to receive deferral under the Convention Against Torture, it's not sufficient that Mr. White demonstrates that there's a culture of discrimination in a particular country. He needs to specify that it's more likely than not that someone in that country, in Jamaica, would torture him with the acquiescence of a public official who would either participate or turn a blind eye to that action. In evaluating Mr. White's probability of torture, the immigration judge ultimately determined what was likely here were that Mr. White would face criminal prosecution for the 2018 buggery and indecent assault convictions, and that is what was likely to happen. And Mr. White hasn't alleged anything that would happen in jail or anything like that to establish who in particular would torture him. The immigration judge considered the fact that Mr. White had this experience with the police where they extorted him, but I think that almost cuts against Mr. White's claim because the police officers were extorting Mr. White because they knew he was gay.
Can I go back to the asylum and withholding question, and specifically the red notice issue, and just figuring out what we do and don't have to decide? Mr. White's lawyers represent that the Department of Justice, quote, does not consider a red notice alone to be a sufficient basis for an arrest because it does not meet the requirements of the Fourth Amendment. Do you agree with that statement?
I agree with that statement. And
Okay.
I think it's reflected in Judge Nelson's opinion in Vila Basura, where I think the reliability and probity of the red notice corresponds with the underlying arrest.
So the government is not asking us to hold that a red notice is invariably sufficient, and that if we were to address that question, we would actually say the answer is no.
Well, it's
That the mere fact that if literally so the government presents, I realize this is sort of artificial and wouldn't happen, but in a hypothetical situation where the only evidence presented to the IJ is a red notice, and there is no other evidence presented to the IJ about the existence of the crime, the government would say the IJ should not find the standard met.
Well, I think that's Barahona and Gonzalez Castillo, and I think the way to, I think
So is that-
DHS could meet its initial burden potentially with the red notice alone to put Mr. White on notice.
But then Mr. White says that's wrong and you shouldn't trust it.
Well, and so I think the way I've conceptualized it, I think there's three buckets of asylum cases generally. There's bucket one, whether you meet the refugee definition, you get asylum as a matter of discretion. Bucket two is where DHS puts on some evidence to trigger the 1248.8D regulatory bar to shift the burden to Mr. White to demonstrate the serious non-political crime bar doesn't apply. And
But I
then
mean,
bucket three is,
it's a very straightforward question, and the answer ought to be equally as straightforward. It says, no, Your Honor, the red notice is not dispositive of itself. It's simply one item of evidence, and in this case, it's one of a number of items of evidence. So this was a straightforward question, and my colleague is indisputably correct, and it's indisputably correct that DHS doesn't regard it as per se dispositive. So why would you?
I'm happy to concede the point, Your Honor, that in this case, DHS presented such a quantum of evidence to meet its initial burden that the court doesn't need to reach the exact issue that the court confronted Barahona and Gonzalez Castillo. My only point was that it could be, I think those cases represent the fact that DHS can trigger its initial burden of proof. And as Your Honor pointed out, if the only thing in the record is the
It's
red
relevant
notice,
but not dispositive, right?
right. And I think if at the end of the day, all that was in the record was the red notice and it wasn't a very detailed red notice, that Mr. White likely would meet his burden of proof. And that's ultimately counterintuitive because DHS triggered the burden of proof. But I think where that's all that was in the record, I think Mr. White or non-citizen could rebut it. And so that's that third bucket of cases. But here, as we've discussed this morning.
That was a long way around the barn to answer the question. Why don't you move on?
Yes, Your Honor. And so I think here DHS easily satisfied its burden of shifting the burden of proof to Mr. White to demonstrate that there were not serious reasons for believing that he committed buggering and indecent assault. We have 2 arrest warrants certified by
Opposing counsel says they did an inadequate probable cause analysis, both the IJ and the BIA. So why do you say they did?
Well, I think the board in its decision recognized, cited the matter of EA and recognized that the ultimate burden of proof here is a probable cause standard. And the immigration judge thoroughly discussed the reasons why DHS met that initial burden here. In conjunction with the 2 warrants are the Interpol red notice, which Mr. White does not contest identifying him with specificity. There's Mr. White's affidavit and testimony that these instances occurred and that he was accused of this crime. Of course, he has a mitigating or an alibi defense that basically he was framed by JR's family for these offenses. And then in addition, there are the 4 Jamaica Observer articles that detail the reasons why the JCF did not obtain warrants until after Mr. White fled the country. And that's because JR didn't make a statement record a statement to the police, which would enable them to get an arrest warrant until January 18th of 2020. And so together, that evidence was sufficient to provide serious reasons to believe that Mr. White had committed these offenses, not to mention this isn't like a case like Gonzalez Castillo or Barahona where the non-citizen outright denies the allegations. Here, Mr. White concedes that he knew the victim, JR, that JR would go over to his house. So this is a case where this didn't come out of the blue. As the agency found, Mr. White's testimony was consistent with someone who had an opportunity to commit the type of offenses that are detailed in the arrest warrants. And Mr. White can't rebut the presumption that the serious non-political crime bar applies because the agency credited all of this other evidence that we've discussed over his self-serving testimony that on January 8th, that JR's family, after knowing him for years, decided to extort him for money, and after a fabricated story about how they made JR's sister pregnant, that they, raised these allegations that he sexually assaulted JR. And Mr. White has not identified any record evidence that compels a finding of credibility. And this case is like the Ninth Circuit's case in Villalobos-Sura, in that there the Ninth Circuit was considering an Interpol red notice for murder with the underlying Salvadoran murder warrant. Villalobos-Sura conceded that he was the person named in the warrant, so there wasn't a dispute that this all might be about someone else. And there, the immigration judge, like here, found that the allegations that Villalobos-Sura engaged in this criminal conduct were more credible than his denial, and the immigration judge made an adverse credibility determination. And so I think that that's similar reasoning here, and I think it's the best analytical framework that the court can look to in resolving a case like this, where there's so much evidence to trigger the serious non-political crime.
Somewhat related to that, Mr. White argues, as I understand it, that yes, I introduced the news articles, and yes, that's me they're talking about, but I only introduced them so that they could be considered in the lane of the Convention Against Torture, and the government was not free, nor was the IJ and the BIA free, to use that for any other purpose, such as serious non-political crime. So, what do you say to that?
I mean, my response is that under 1229A, when evidence comes into the record, the fact finder can consider it. I mean, I don't know how the immigration judge is supposed to segregate out, I can use this evidence for purpose A, but not purpose B.
Can I move to asking you a little bit about the cat claim? Because I will confess this is the area where I'm more troubled by the BIA and IJ's treatments. So your friend on the other side sort of began by reading a letter in which someone threatened to do something to Mr. White that sounds like... The other problem is that, right, the statute uses torture to mean two different things. It means doing the bad thing, and then it means in a way that is the responsibility of the government. So when I say doing the bad thing, okay. So there's a letter that your friend on the other side read that sure sounds like a threat to do a bad thing that would be a qualifying bad thing under the CAT, right? Again, how credible it is, but that's a threat to do something that the CAT would define as conduct rising to the level of torture.
Potentially, yes, Your Honor.
Okay. And then the second requirement is it's not enough if a private person does the bad thing to you. The government has to be responsible, either in the sense that the person who did it to you is a government agent, or the government looks the other way, lets it happen, yada, 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 right? And your friend on the other side essentially says that the BIA seems to make a category mistake, because what the BIA says, look, if he's sent back to Jamaica, the most likely thing to happen is that he's going to go through the criminal justice system in Jamaica, and the criminal justice system in Jamaica is generally okay, at least, and he'll be convicted or acquitted. But your friend on the other side said that doesn't really respond to the heart of his CAT claim. The heart of his CAT claim is not what the government will do to him directly, it's what private vigilantes will do to him directly, and about which the government will then do nothing. And I will confess, I think at minimum, the BIA and IJ's treatment of that precise thing is a little skimpy. So would you like to try to convince me that they adequately considered that argument rather than responded to an argument he didn't really make?
Yes, Your Honor. So I think well, as a threshold matter, I think that the board adequately separated out the factual findings from the immigration judge. And the second paragraph in AR-11, where it's addressing the CAT claims.
Get a little closer.
Oh, I'm sorry.
I'm having trouble here.
The second paragraph in AR-11 is where the board is reviewing de novo the legal aspects of Mr. White's Convention Against Torture claim. And I think another point I would make is that if Mr. White cannot establish that it's more likely than not that he would be tortured, that's a threshold dispositive basis.
When you say torture, the bad thing. No.
Yeah, the bad action. That's
no, because you know what I'm saying. Like the problem is the statute uses torture to mean two different things. It's like part A, but also the whole category, and it gets really confusing sometimes.
Yes, Your Honor. So more likely than not to commit an action, torture or murder that would rise to the level of harm under the Convention Against Torture. And so to prevail here, Mr. White needs to show that torturous action is more likely than not to occur, and that a public official would acquiesce to it. And I think that I agree with you that agency's acquiescence analysis here isn't extensive, but I think that that corresponds with the fact that the agency engaged in an extensive analysis, prospective analysis.
Doesn't our precedent suggest that you can't always equate doing nothing with acquiescence? I mean, let's take the United States. There are all sorts of heinous crimes that are committed in this country about which the government is lackadaisical or doesn't pursue with sufficient vigilance, and sometimes it doesn't do anything. But the fact that a crime is committed and the government does nothing, it doesn't mean that the government is acquiescing in the misconduct. It may mean that it just has a lack of resources, or it may mean that it doesn't have sufficient evidence, or that it doesn't have sufficient clues, or whatever. But there are, unfortunately, sadly, a lot of crimes in a lot of countries, including our own, where the government is slow to act or does nothing, but not for a moment do I think that the government or anyone else is acquiescing. In the context, I'm asking you whether you have to have some affirmative act to demonstrate acquiescence, or whether the acquiescence can be demonstrated by a sense of omission. I suppose it could be doing nothing could be acquiescence if something was committed, a flagrant crime was committed in the sight of government officials or right under the eyesight of government officials. But as a general matter, it's probably hard to equate inaction with acquiescence, although there might be situations in which the inaction was so flagrant, given the government's notice, that it was acquiescence.
Right, Your Honor. I mean, the Regulation 1208.18 that defines torture looks to the prior awareness of the public official of the action that constitutes torture. So the fact that the Jamaican government is unable to provide perfect protection to all of its citizens against all crimes is not sufficient for Mr. White to meet his burden of proof.
Well, but it's not all citizens for all crimes. This is where his country conditioned evidence comes in. It's that the government systematically doesn't enforce the laws that are designed to protect LGBTQ people, right? That's what the country conditions evidence at least tends to suggest.
I think I have to concede that there's certainly evidence of discrimination in the
So can I go back? You mentioned AR-11, and I'm glad you did. I pulled it up. On AR-11, there's this carryover paragraph where the BIA is talking about the thing you and I discussed earlier, which is like, what's probably going to happen is he's going to be tried. Okay. And that we concede is not really responsive to his primary cat argument. So then there's this paragraph, the last substantive, that's the paragraph you're telling me where the BIA adequately addresses his actual cat argument?
I think that's where yes.
Is there somewhere else where you're telling me?
No, I don't think so, Your Honor.
And so that to me, maybe this is enough, because I know the standard review is, but these to me just sound like 4 conclusory statements in a row, right? The IJ determined there was insufficient evidence of acquiescence. No explanation of why that is. The IJ also properly determined he could not establish each step in the hypothetical chain. No explanation. The IJ properly determined that assessing his fear of harm and the police directly as well as individuals would harm him collectively did not have to greater 50%. That's just another completely conclusory statement. Therefore, which is a little weird because these are just 3 conclusory statements in a row. Therefore, the IJ properly decided his request for deferral of removal under CAT. That is the sum total of the BIA's analysis responding to his actual argument.
Well, and I concede it's not a model of clarity. I think the argument that Mr. White raised in his administrative appeal brief focused on 2 articles, which is why we raised an exhaustion point as to his reliance on other country conditions evidence of acquiescence in this argument.
I thought your point with respect to Judge Hyten's good comment was that the petitioner bears the burden of establishing non-acquiescence. And that, of establishing acquiescence. and that there isn't a record here that establishes acquiescence. And I think that my good colleague is absolutely right that it may have been a very abbreviated treatment, but as to that point, a petitioner would bear the burden, would it not?
He does bear the burden.
And there's got to be something more before the fact finder.
Of course, and that was where I was going with the administrative appeal brief. Mr. White references a shadow report to the United Nations from 2011 and quotes this sentence, but the sentence doesn't have any evidence. And I think that's fairly the theme of Mr. White's case here. It's still not clear to me who exactly in Jamaica is more likely than not to torture.
Well, what do you say in response to your friend's January 6th hypothetical, which I thought was a little, I mean, it actually, I think it kind of works, right? Vice President Pence did not know who specifically was about to try to kill him, but does that really matter? If there's a mob of people at your door, does it matter that I can identify the members of the mob?
I take the point. I think it's a good argument, but the evidence here is not sufficient to establish that there are mobs of this nature in Jamaica. Much of the evidence that Mr. White relies on, even if it's recently dated, like the article that references the case in the American Court on Human Rights, that's an individual who lived in Canada for 13 years. So this is...
Sure, I guess I'm just saying the fact that he can't name the name doesn't necessarily prevent him from showing up.
No, I think if the Human Rights Report said that every day a mob of people roams the street and kills someone, of course, I think that that would meet his burden of proof. And the issue here is that Mr. White did not present that type of evidence here to meet his burden of demonstrating that a public official would acquiesce, on top of the fact that he has not laid out a chain of events where someone in Jamaica would be motivated to torture Mr. White. And I would just, before...
Oh, your time is up.
Thank you, Your Honor.
Unless my colleagues have additional questions. Steve, your time is up.
Thank you, Your Honor.
All right, Ms. Qureshi, you have some rebuttal time.
Yes, Your Honor, and I'll try to be brief. Just a few quick points. The government mentioned the initial burden, and I think that's a very important point here. The IJ and BIA appeared to say that the government has a lower burden, that they don't have to show probable cause, and that's why they shifted the burden on Mr. White, and that argument was squarely rejected by both the 8th Circuit in Barahona and the 9th Circuit in Gonzales-Castillo, where the BIA made a similar legal error, and both courts looked at the statutory language and said it says serious reasons to believe. And that is why the government needs to show probable cause before the burden can be shifted back to...
So are you saying that they didn't show probable cause, or that the government says it doesn't have to show probable cause?
The government is saying it doesn't have to show probable cause, Your Honor. And that is what the IJ and BIA appear to have done. They cited the regulation they cited matter of WERB, which was overturned by Barahona.
Well, even if that's what they said, and I'm not sure that's accurate, both the IJ and the BIA said, yeah, there's probable cause.
Well, Your Honor, the BIA, again, acknowledged in a footnote that they make a probable cause finding. But again, the initial burden of proof should have been on the government to show probable cause, and the board and the IJ stated, well, the government doesn't have to show probable cause, that the burden is on Mr. White. Once DHS presents some evidence, then the burden is on Mr. White to prove by a preponderance of the evidence that probable cause is not met. And that is, again, I would point, Your Honors, to both Barahona and Gonzales-Castillo, where the board made the same error. In regards to the actual a probable cause finding, while this court can reverse on legal error alone based on the incorrect burden allocation, this court has to look at two things under Wilhelm, both the reliability of the evidence and the basis of knowledge. And Judge Wilkinson, in Torchinsky, you wrote that an arrest warrant does not mean it is per se proper or reliable. You need to look at what is the corroborating information that forms the basis of the arrest warrant. And here DHS has said that there are these inflammatory articles that were the basis of the arrest warrant. Judge Agee, we're not arguing that the observer articles can't be considered under probable cause, but simply that they do not meet probable cause for all of the reasons that we mentioned. I recognize that my time is coming to a close. I also just wanted to acknowledge both the due process arguments that Mr. White has raised, as well as the issue with credibility, in case this court has any questions about those.
Thank you so much.
Thank you.
If I can make one more point, or
Did you have
ask one
another
more
question?
question, I guess one of the things that's troubled me about Mr. White's case here, this may be my misapprehension of it, but, you know, every case turns on context. And the context of this case is that you have an individual in a position of authority, in a position of trust, who then is accused of abusing that position and abusing that trust and molesting a child. And it just seems like that's the thrust of that problem is just not something that Mr. White has addressed. There are a lot of other arguments that are more generic on more global societal problems. But in a case, it's the facts of that case. And the abuse of trust, the abuse of power, and the molestation of a child is what we have in this case.
And Your Honor, if I may respond, like my colleague Ms. Nielsen said, throughout the history of this case, Mr. White has vehemently denied those allegations, including denied, the age of the complainant in the case. But again, Your Honor, I would point you to the probable cause standard. Here, you were looking at whether this evidence is sufficiently corroborated, is sufficiently reliable, and under this court's precedent and the Supreme Court precedent, it clearly does not meet the probable cause standard. Thank you, Your Honor.
So I wanted to address a few of the questions that Your Honors had for my colleague from DOJ. So first, Judge Wilkinson, and you characterized the situation in Jamaica as potentially being that the government doesn't have the resources to control people, and no government is perfect. Of course, that's true. The legal standard isn't that a government must be perfect. It's do they acquiesce in the torture. So I wanted to point you to a couple of pieces of evidence in the record. One from the 2019 IAHCR International something on Human Rights Commission, Inter-American Human Rights Commission ruling that says at AR 387, quote, it also advised training for the police and security forces who have long been complicit in or perpetrators of violence and harassment against LGBT Jamaicans. And likewise, in the UNHCR Shadow Report at AR 546, it says, violent crimes against LGBT individuals are gruesome, widespread, and facilitated by the inaction and at times participation of government actors. My colleague from DOJ faulted that report as coming from sources that are not cited, but that's the same thing that happens in the Department of State Human Rights Report, which have universally been found to be a reliable source. And that Human Rights Report likewise says that the Buggery Law, quote, legitimizes violence against LGBT people. Judge Hayden, I also wanted to respond. You pointed out correctly, in my opinion, that this final paragraph in the Board of Immigration Appeals decision does nothing but state legal conclusions. And one of those legal conclusions that it states that the immigration judge properly determined in assessing the fear of harm, that it wouldn't collectively add up to over 50%. Basically, the immigration judge decision as well at the AR 131 also just has a single sentence that says, also I'm aggregating the harm and it doesn't add up. So the analysis by the IJ that the BIA is relying on also doesn't exist. So that's also problematic. And then Judge AJ, I did want to address your point about, well, if once you introduce the newspaper articles, they're in the record, you can't use them for one purpose and not the other. But the purpose they were introduced for was not for the truth of the matter asserted. We never believed that anything in those articles was true. The reason that they were introduced is to show that while Mr. White could safely lead a life as a closeted gay man before he left Jamaica, that cat is out of the bag. The whole world knows that he's gay now and that he's been accused of molesting an alleged minor. So the point of that article is not that this actually happened. It's that everybody in Jamaica believes that this happened, or at least it knows that he's been accused of these things.
All right, we thank you.
All right, thank you, Your Honor.
We will adjourn court for the day.